Well, just one clarification from the side.
23rd.
23rd. How like?
May I please your lordship? Hello. Item number 43, my lord, today's list, my lord. I have filed an affidavit in reply, my lord. The same may kindly be called to record only this much. Okay. Lord. May I please your lordship?
Lord, this is a MBBS admission matter, my lord. The petitioner, he is a physically challenged person, my lord. May I pray for listing it tomorrow, my lord? Arbitrarily, his candidature has not been selected, my lord. He appeared in NEET exam, my lord, and she was, my lord, allotted a seat in, my lord, the medical colleges in Assam. But in spite of that, in the first counseling, my lord, her candidature has not been allowed. Tomorrow, my lord, because most possibly second counseling might take place on Sunday, my lord. I'm deeply obliged.
Yeah, please, sir. I'm praying for listing my motion matter on Monday.
Why Monday?
Monday, my motion matter I have filed today.
You filed today?
Yes, sir.
We'll have to come to
Okay.
May I please, your lordship? My lord, I would like to listing of a case, your lordship. Prayer for listing of a case of contempt case, your lordship. That this contempt case was last listed in the year 2023. But can it be on your lordship on a Monday, your lordship?
See, next week it's all going to be very difficult.
Yes, Lordship.
Cases are very less.
Yes, lordship. I understand. Even then, your lordship, if lordship allows my mention, maybe your lordship, because this contempt case was last listed in the month of September 2023, your lordship.
We will have it on the opening day.
My lord.
Mayor, please, your lordship, my lord. With the consent from others, sir, I beg to mention item number 5, lordship. The matter may be listed after vacation, lordship.
You are praying for
NNB Chaudhary,
on request of behalf of
petitioner, lordship. Deeply obliged.
Hey, please, your lordship, my lord.
My lord, with concern of the other side, my lord, I beg to mention item number 35, my lord.
Yes.
My lord, we have some difficulty today, my lord. Let the matter may come immediately after vacation, my lord.
You are praying on behalf of
Petitioner, my lord, HP Gwala, my lord.
have you taken the consent?
Yes,
My lord.
On request made by
Obliged.
Item 1 of daily list, motion.
So today also the matter is fixed for instruction. Last time when they submitted that they have received instruction, but that is not sufficient. So on fourth occasion, lordship, they have took time to get instruction. Already this is the fourth round of litigation, lordship. In the earlier 3 occasions, mandamus is given to.
Your lordship, in this matter, NJ Khatanier
No,
is
B. Kaushik was there last occasion.
and
Kaushik, kindly see order the 29th of February. B. Kaushik informed that he received instruction last week. B. Kaushik.
Your lordship, today matter will be appearing by NJ Khatanier, your lordship. He is not here. Kindly pass over the matter for time being.
Okay, wait for some time.
Lord.
Let's just see what.
Lordship.
Two.
What keeps in about it.
Lordship, please.
Any decision taken?
Lordship, I am appearing for FLSC, your lordship. Lordship, yesterday meeting has been, meeting was held, your lordship, but the question is that your CID report is not received, your lordship. That is why meeting could not took any decision yesterday, your lordship. Lordship, allow us some time, as soon as CID report will come, your lordship.
No, when are you expecting the CID report?
Lordship, that's up to Home Department, your lordship. We have no control over CID, your lordship.
My difficulty is on first, the classes are starting. So I might be, because in under the rules also, the original notification, your lordships, I am permitted for a provisional admission. At least I should be allowed, let them do their exercises, there's no problem. But otherwise, the entire process is going to get halted because of this. In fact, in this second writ petition, your lordships 440 at page 99, the original notification which we are referring on the last date, your lordship.
That will.
Yes, that in fact says that a provisional can also be done. I just read it to your lordships, it will become clear. Page 99.
Yes.
Page 99, para 8. In case of any delay in finalizing the proceedings, and in the meanwhile, the last date for submission into educational institution or appointment to officer in post is getting expired, the candidate shall be admitted by the principal or such authority competent on behalf or appointed on basis of a social status certificate already issued or an affidavit duly sworn by the parent and guardian candidate before the competent authority. So I should be at least permitted. That's all I'm saying. Let them do their exercise.
Okay, MS.
Ardeka.
Ardeka,
We are
Learned,
not a party in the petition, your lordship.
Learned Council. Appearing on behalf of the state level caste scrutiny committee submits that a meeting was held on
Yesterday, your lordship.
yesterday was what the 25th of September 2024. However, no final decision would be taken in as much as the CIT report. The CIT report. No. However, no decision could be taken as the CIT report was not placed before the committee. Stop. She therefore prays for some more time to enable the state level caste scrutiny committee to take a final decision with regard to the caste certificate of the petitioner. Stop. Mr. R.P. Fukar, learned counsel for the petitioner, submits that the admission,
Yes. Provisional admissions can be given.
that the admission for the what is this order you're passing?
Yes, that's the order in terms of this, the clause that I pointed out, your lordships. A similar direction was also given in terms of the same clause. That's the reason I've given that order for your lordship's convenience. The last paragraph of the order. However, such admission of the petition in the MBBS course for 2021 in Guwahati Medical College shall be provisional and subject to the result of the inquiry in regards to the TGL certificate of the petitioner to be made in
That
by students.
the admission for the MBBS course 2024-25, correct?
Yes,
Would be starting from 1st of
1st of October.
October 2024. Stop. He therefore submits that till the state level caste committee takes a final decision, provisional admission may be permitted for the petition.
Yes.
Stop. But
Seat is already got for you.
after hearing the parties, which respondent is to be directed?
DME,
The
DME and the principal. Just tell your lordships the
concerned authorities.
DME. I just tell your lordships. A 5.
Admission for the first year. Admission for the first year. MBBS/BDS course session dash 2024. The after hearing the parties, the director of medical
education.
as well as the principal, correct?
Yes, number
Of
3.
Respondent number
Principal has not been made a party because till that time there was no admission has happened.
Hmm.
This is prior to that.
So this, which principal is it?
Tejpur Medical College.
The principal, Tezpur Medical College.
Yes.
Is directed to give provisional admission to the petitioner.
Yes.
Stop. However, such provisional admission shall be subject to the outcome of this week.
Grateful. Extremely grateful.
When we want, list the matter again on.
Before, Lord, it's up to them, your lordship. We have to.
Before vacation, it will be difficult.
It won't make
No,
sense.
my lord,
also.
because it's a medical admission, madam. Before vacation can be taken up, madam. We will also pursue the, my lord, concerned department, the home department.
Then I need
It
it
is-
before vacation.
See, the issue is that CIT report is not coming.
My lord.
And after that, a procedure
When
has
is
to
the
be followed.
CIT report going to come? We don't know.
No, my lord, within 1 week, at least CIT, they can give the report, my lord. Only field verification is required. Apart from that, every document is with the concerned with deputy commissioner, my lord.
So when are we getting this? When are
My
we?
lord, before vacation, my lord, I need it, my lord.
After that,
No, my lord,
we-
my
after
lord,
that, they will have to hear me
my
also
lord-
because procedurally they'll have to issue a
My lord,
notice. I'll have
whatever
to
is
go and
there,
give an
because my lord,
explanation.
provisional admission, my lord, they are checking, my lord. Because if before the provisional vacation, my lord, this report come, my lord, there is no occasion to keep the post.
We'll have it on the opening day of the.
No, my lord, may please to take up before vacation, my lord.
Okay,
Last
if on that day, if nothing happens, then I'm going to pass some orders.
No, my lord, even my lord has already stated in the order that there is a provisional admission, my lord.
Provisional
What-
admission
what
we
we
shall
are
be
saying, my lord.
Correct. And it is all
subject to the outcome of the swift petition.
No, my lord, because my lord, once he get the admission, my lord, his right will come, my lord.
Oh,
Then, my lord, it's.
What is, then what is the point
My
of
lord,
this court saying that
Then, my lord, admission
the
is.
provisional
my lord.
admission shall be subject to the outcome of this swift
No, my
petition?
lord, even my lord, admission will be started from the 1st October. Even we don't, cannot say that it's 1st October, 30 October, my lord. If before that, my lord, scrutiny report come, my lord, there is no occasion to fill up the post, my lord. Therefore, my lord, I am praying that before vacation, my lord, matter may be fixed, my lord.
I don't understand, CIT report will come next week.
My lord, we'll
Petitioner
try,
will
my lord,
have,
because, my lord,
petitioner will have to be heard. A date has to be fixed.
correct. That's the process under the
Hearing has to
notification.
take place. After the hearing, the committee will again sit down,
Absolutely.
then pass orders. Meantime, it will be puja.
So last day, my lord, at least, last day, my lord, we can take an endeavor, my lord. Considering the urgency of the matter.
If you want it, we'll have it on third. List the
No
matter
problem.
again.
No problem. Let me on top. No issues. It's just an unnecessary exercise for the court. That's all.
Both the petition may be served upon after.
Okay.
I'll serve it.
please
I'll serve.
us.
I'll serve. No,
Both the.
both the retribution I'll give it. No problem.
Alright.
Great.
39 of supplementary list, motion.
May I please, your lordship? My lord, item 39 and 40, the petitioners are challenging the promotional recruitment process that is going on. Headmaster of high school, my lord. These are connected with item number 24 to 36, my lord, 34.
That headmaster one, your lord.
So I'm just praying for notice in this matter, item number 39 and 40. And similar interim order as passed in item number 26, my lord, that this will be subject to outcome of the repetition.
Subject picture, science.
That is any promotion to the post of headmaster so affected in
No,
terms of the process. Correct.
Are you ready with those items?
Your lordship, those earlier one, your lordship, today we are going to file affidavit. And another that analogous tag matter, that last one, Bimal Chandra and Intas, that copy had not been served upon us.
Okay, then you do one thing.
Ma'am.
You wait for some time, let those matters be called up. When that is called up, I'll consider this to read.
Deeply impressed.
41.
Hey, pleasure, Lordship.
Hmm.
Lordship, in this matter, petitioner is the most science most graduation teacher, my lord, of his school, joining his service on 1/1/1992, my lord. His school name Bonda MA School, my lord, and amalgamation Raghunath Chaudhary High School, my lord. And respondent number 4, which is junior to the petitioner holding the post, my lord, of headmaster.
Yes, who appears? This is the same thing that headmaster.
Yes, my lord.
Yeah, we can take up with those matters. We'll take up with those matters.
Yes, my lord.
When it's not.
Obliged, my lord.
4, admission.
Let us.
Lordship, in this case, Lordship, His Excellency Honorable Chancellor has, Lordship, yesterday instructed us to appear in this matter on behalf of the Chancellor. So, Lordship, we need some time, Lordship. Lordship may fix it immediately after vacation. In the meantime, we will construct the file and we will argue, Lordship. In this case, Honorable, as per Chancellor's office notification, Lordship, as you will appear in this case, Lordship.
Okay, heard Mr. T. Chakravarti, learner council. On request made by Mr. K. Gogol.
Lordship, Lordship.
You have 40?
For the respondent number 1, Lordship.
As well as the Guwahati University.
Respondent number 1 and we also appear Guwahati University also, Lordship.
Okay.
1 to 5, Lordship.
1 to 5.
For the phone number 1 to 5. Please the matter immediately after the puja.
Lordship.
Date may be fixed, my lord,
I'm
already.
not fixing dates after puja because it's very difficult.
Lordship.
It's
So
a third
if-
return, my
if-
lord.
No,
Yes.
anyway, if some urgency is there, you can make a mention.
make a
I'll
mention.
get it.
Lordship. Pleasure, Lordship. Pleasure.
42,
Yes, Buyan, could you,
Yes, my lord, my learned friend will be appearing. He is entering appearance for respondent number 5.
so are you ready to hear the matter or?
Yes, I would like to adopt the arguments advanced by my senior counsel.
Okay.
I take your lordship straight to paragraph 2, minute. Page 4. Just to have a grasp of the entire matter. Paragraph 2. Page 4. Married. That the writ petitioner humbly states that he was appointed duly as part-time teacher of Kesidas Commerce College, so and so, in 1989. It is important, my lord. In 1989, and thereafter his service was regularized as a whole-time founder teacher with effect from 24/8/1990 in the said college, which is a provincialized college under the government of Assam. The writ petitioner has also served the college as the head of the Department of Finance till 24, and his entire service career in the college has been without any blemish and to the total satisfaction of the authorities concerned. Now, next page. However, a junior teacher, Dr. Bhavabhuti Sharma, respondent number 5 in the instant case, whose joining date was with effect from 7/9/92, has presently been allowed to discharge the functions of the vice principal of the college since the last part of 2021 without any legal and lawful basis, including that of the UGC Regulation 2018 in this regard. Now, paragraph 3. The writ petitioner humbly states that prior to that and also thereafter on numerous occasions, the writ petitioner has approached the respondent authorities praying for his due appointment, engagement, designation as the vice principal of the college without any positive result till date. Next page, minute. It would be relevant to state here that the writ petitioner has already submitted representations, particularly dated 1/11/2021, 9/5/2023, along with RTI application dated 36/2022, followed by RTI appeal dated 7/9/2022, through an advocate in this regard, without any fruitful response from the respondent authorities. Now, 4 minutes. Down below. That the writ petitioner humbly states that in the relevant UGC regulations of 2018, it has been clearly provided in clause 416 that vice principal, it is important, below. An existing senior faculty member may be designated as vice principal by the governing body of the college on the recommendation of the principal for a tenure of 2 years, who can be assigned specific activities in addition to his her next page, minute. Existing responsibilities during the absence of the principal for any reason, the vice principal shall exercise the powers of the principal. So the key words is an existing senior faculty member. So he is the senior most founder teacher of the college. The first offer should go to him, but I don't know for what reason that offer has not been made to him. Instead, the private respondent number 5 who is much junior to the writ petitioner. He has been offered and he has been functioning till date. My lord, after filing of this writ petition, they have raised some allegations. Some stigmatic sentences have been used regarding, my lord, my contesting election in 1991, while the college was a venture college. College was granted deficit grants in aid status in 1998. He contested in 1991. At that time, my lord, relevant period, it was not barred by any law of the land. Deficit grants in aid was granted in 1998. He contested in 1991. And the college was provincialized in 2005. So that is one aspect. Second, my lord, now some allegations have been raised that he got PhD from an university which is not recognized. But that was not true. That is not true, my lord. Since in my reply, my lord, I stated that it is UGC recognized as well as state recognized university. And for that, my lord, no inquiry, nothing has been, my lord, made till date, my lord, that he is not the founder teacher. He is not functioning since 1989, nothing at all, my lord. But these allegations have been raised after filing of this writ petition, my lord. My lord, matter is in very short campus, my lord. I take your lordship straight to the affidavit in opposition filed by my learned friend, my lord, on behalf of the college.
1 minute.
Affidavit in opposition, my lord.
When was the order issued for the response number 5 for appointment as
Way back in 2021. I have, my lord, filed so many, my lord, applications, so many representations.
no. The allowing the response number 5 to function as vice principal?
Paragraph 2, page 5, my lord, in the last part of 2021. I could not get hold of that, my lord, document, my lord, as yet, my lord. I have tried in vain, but could not get, my lord. Anyway, my lord, the statement has been made in page 5, the 5th line.
And what is this GB resolution?
GB resolution, my lord, it has not been annexed, my lord. By in the affidavit in opposition also, my lord, it has not been annexed.
No. You have annexure A and B.
AB, my lord, annexure A, my lord, it is the resolution of the governing body of that particular college, my lord, page 13, my lord.
Regarding his appointment, regarding the appointment of the petitioner.
May I read that annexure, my lord, page 13?
Oh, this is a petitioner.
Read petition, my lord. It has been controverted now, my lord, after filing of this writ petition, and in the fag end, my lord, almost 2-3 days are left. Now they are raising that allegation that it is not true. Some scrutiny committee's report, which has not been adopted by the governing body, which has not been furnished to the writ petitioner, my lord, only 2-3 days left, and these allegations have come up that he contested election, that his PhD offering university is not recognized, and so many things, my lord. But your lordship is aware that for, my lord, raising those allegations, my lord, he should have been given some opportunity to controvert that, my lord, some sort of inquiry, the arena of the principles of natural justice, entire things should come. Otherwise, in the arena of service jurisprudence, my lord, it has got no value, my lord, those allegations, my lord. Anyway, my lord, this annexure A, it will clarify, my lord, it still, my lord, stands, my lord. Annexure A, very important, my lord. Page 13. The governing body meeting held on 29 September 1997, under the chairmanship of so-and-so, President Governing Body, Kesidas Commerce College at the college premises, adopted the following resolution. Resolution number 5. The secretary reported that Sri Murali Krishna Sharma, the writ petitioner, my lord, is a founder teacher
and has been working as a part-time lecturer in commerce since 24/8/1990. Milord, the private respondent, Milord, was appointed in 92, and he was working, the read petitioner was working as a part-time lecturer since 24/8/1990. Still, Milord, up to Milord 39 Milord of this month, Milord, he has been Milord serving as a lecturer, Milord, now whole-time lecturer, Milord, and his service has been regularized. And therefore, he be regularized as a whole-time lecturer and founder teacher with effect from 24/8/1990. This is one part, Milord. Now it has been followed by an office order, Milord. The next page, Milord. Type copy, Milord, page 14, Annex B. The services of Sri Murali Krishna Sharma is regularized as whole-time and founder teacher in the Department of Commerce with effect from 24/8/1990. This is as per the decision of the governing body meeting held on 29/9/1997. So, Milord, this seals the entire thing, Milord. His appointment is with effect from 90, and the private respondent's service is with effect from 1992. So he's senior to the private respondent. So the
Year from 1990.
24/8/1990.
And the respondent?
Respondent number 5, with effect from 7/9/1992.
Where is that?
Page 5, third line. It has not been controverted as yet, Milord, in the affidavit in opposition. So, Milord, 2 years senior to the private respondent. So the first offer should go to the writ petitioner. But in spite of that, in spite of his repeated process, Milord, Milord, he has not been offered that post. And it is not a post, Milord. It is a simply designation, Milord. And may I draw your lordship attention to one case, Milord, decided by this honorable court, 2018 3 GLT 235. I won't take much time, Milord. Dr. Gangadhar Das versus State of Assam and others. Regarding experience in sanctioned post or non-sanctioned post, etc., Milord, while relying upon the Asim Kumar Bose case of the Supreme Court, Milord, I take your lordship straight to paragraph 7, Milord. The reliance on Dr. Asim Kumar Bose case, paragraph 7, Milord. Dr. So-and-so, learned senior counsel, also refers to the pronouncement of the Honorable Supreme Court rendered in Dr. Asim Kumar Bose versus Union of India and others, reported in 1983, so-and-so, wherein, while examining the requirement of teaching experience, the Honorable Supreme Court had concluded that there is hardly any difference so far as teaching experience is concerned, whether it is acquired on a regular appointment or as a specialist in a teaching hospital with an ex officio designation. Thereafter, Milord, we can skip other paragraph. For this matter, Milord, paragraph 13 and 15. In a similar tune, Milord, 13 and 15. Paragraph 13. For the purpose, the conclusion of this the Honorable Supreme Court in paragraph 29 in Dr. Asim Kumar Bose Supra would also be relevant, wherein it was held that there is hardly any difference so far as teaching experience is concerned, whether it is acquired on a regular appointment or as a specialist, etc., in some other allied manner. Then the conclusion, Milord, of this Honorable Court. Paragraph 15. From the said point of view also, it cannot be said that the teaching experience of the respondent number 6 for the period from so-and-so to so-and-so in the Cotton College, Guwahati, against a non-sanctioned post cannot be construed to be a teaching experience. So, Milord, relying on Asim Kumar Bose, whether regular appointment or an appointment on ad hoc, ex officio designation or specialist, Milord, that should be counted, Milord. So, whether he is a whole-time teacher part-time teacher, it won't matter, my lord.
But that is not the issue here.
My lord, since my lord, the seniority status is in the issue, my lord.
The seniority status
sought
is,
to-
the R5 is from 1992.
And
You are
I am
from
from
1990.
1990.
That's all.
So that offer should go to me, my lord. And hardly 2-3 days working days left now. So, my lord, I have come late to the court. I understand, my lord, but your lordship will understand, my lord, that psychological, my lord, environment, my lord.
What are they saying in the
Going against the college authorities at the fag end of his career, just for that vice principalship. So, my lord,
Where is that counter?
my lord,
It's a record.
it starts from page 18, my lord. Running page 18, my lord. Affidavit in opposition. My lord, page 36, my lord, that order issued by the Director of Higher Education, that the post of vice principal, my lord, there is no such post, my lord.
Hmm?
It is only a designation, my lord. Page 36. May I read, my lord? It is dated 6/7/2018. It is come to notice that some colleges have submitted proposals for approval of vice principal in their respective colleges, but no post of vice principal for provincialized colleges of Assam has been sanctioned, created by the GOVT till date. Hence, no proposal for approval for holding the post of vice principal will be entertained by this directorate. So, my lord, since it's not a post, so, my lord, the government of Assam has no part to play to here, my lord. And now page 37, Annexure D. They want to project that his appointments since 1990 is dubious. But this report, my lord, has not been adopted by the governing body as yet. No notice, no order, nothing, my lord. No inquiry. Now, down below, my lord. Paragraph 5, page 37. Paragraph 4 and 5. Subsequently, he was, that Murali Krishna Sharma, my lord, the writ petitioner, was appointed as whole-time lecturer in the Department of Commerce with effect from 1/6/1996 by the resolution number 3 dated so and so. The resolution is resolved that Sri Murali Krishna Sharma, a part-time lecturer in commerce working since 1989. He has been working since 1989 as part-time lecturer, be appointed as whole-time lecturer with effect from 1/6/96 at a consolidated salary of so and so as a founder teacher of this college. Now, next paragraph. It is a resolution of 1996, my lord, governing body resolution. Now, paragraph 5. Then again, his services has been regularized as whole-time lecturer with effect from 14/8/90 by the resolution number 5 dated 29/9/97, which is also a doubtful one. This is scrutiny committee's, my lord, finding. The second resolution of the governing body is a doubtful one. The resolution is resolved that Sri Deepak Burman be appointed as head of the Department of Assamese with immediate effect, and the services of Sri Murali Krishna Sharma be regularized with effect from 24/8/90. So it is the finding of a committee, my lord, and that was not adopted by the governing body as yet. No communication, nothing that of that sort, my lord, has been communicated to the writ petitioner as yet. But my lord,
Let us read the whole resolution.
my lord. May I read, my lord? It starts from, my lord, page 37, my lord. Reports of the scrutiny committee for fixation of seniority of the lecturers who raised objections in this regard as constituted by the governing body by the resolution number 5 dated 19/11/98, part A. Part A is regarding the writ petitioner. Regarding seniority between Sri Prasanta Kumar Sharma lecturer, Department of Commerce, and Sri Murali Krishna Sharma, lecturer, Department of Commerce, we record the following facts as noted below. 1. As per statement made by Sri Murali Krishna Sharma that he joined in Kesidas Commerce College as part-time lecturer on 24/8/90, but there is no supporting document, that is appointment letter, joining report, and also governing body's resolution regarding the appointment. 2. He was granted lien in March 91. It is important, my lord. March 91. For 5 years for contesting general election in 1991 by the then principal and secretary without the knowledge of the governing body. The grant of lien to a part-time lecturer is illegal and therefore Sri Murali Krishna Sharma is not entitled to lien. It is not true to the facts, my lord. At that time, relevant period, my lord, since the college was a private venture college, my lord, so he can contest, my lord. And he has been allowed the then principal and secretary of the governing body. 3. Again, he was appointed as a part-time lecturer for 3 months by the letter number so-and-so dated 3/1/96 and again extended for 3 months by the letter number so-and-so dated 3/4/1996. 4. Subsequently, he was appointed as whole-time lecturer in the Department of Commerce with effect from 1/6/96 by the resolution number so dated so-and-so. The resolution is resolved that Sri Murali Krishna Sharma, a part-time lecturer in commerce, working since 1989. It is important, my lord. Working since 1989 as part-time lecturer, be appointed as whole-time lecturer with effect from 1/6/96 at a consolidated salary of so-and-so per month as a founder teacher of this college. Subsequently, my lord, this scrutiny committee has, my lord, given the, my lord, stamp in favor of this resolution, my lord. The second resolution, my lord, of 97 is a dubious one as per the scrutiny committee's report. So if we go by the first resolution of 96, then it contains that he has been working since 1989 as a part-time teacher. So if the scrutiny committee accepts that resolution of 96, then it is clear that he has been working since 1989 as part-time lecturer. Anyway, my lord, next para 5. Then again, his services has been regularized as whole-time lecturer with effect from 14/8/90 by the resolution number so-and-so dated 29/9/97, which is also a doubtful one. The result, there, my lord, comment that doubtful one. The resolution is resolved that Sri Deepak Burman be appointed as head of department Assamese with immediate effect, and the services of Sri Murali Krishna Sharma be regularized with effect from 24/8/90. Next page, my lord, page 38. Just 6-7 lines, my lord. There was no mention of suppression of resolution number 3 dated 17/6/96. In case of not suppression, supersession of resolution number 3 dated 17/6/96. 6. In case of appointment of Sri Murali Krishna Sharma as part-time or whole-time lecturer, there was not any advertisement in newspaper. 7. Sri Prasanta Kumar Sharma, who complained about seniority, was appointed as lecturer in the Department of Commerce with effect from 4/11/94, and since then he is working in the college. Now the recommendation part. There are 2 conflicting resolutions of the governing body regarding appointment of Sri Murali Krishna Sharma as whole-time lecturer. The first is resolution number 3 dated 17/6/96, and the second is resolution number 5 dated 29/9/97. The second resolution is very much doubtful and not depends upon real facts, therefore it should be deleted. So that was the recommendation, but it has not been adopted in the governing body. It has not been communicated to the petitioner to rebut it, nothing else, my lord. So in the eyes of law, my lord, it has got no legal status. There are so many cases in the Supreme Court as well as this Honorable Court. It is only a report of a scrutiny committee. And totally biased, my lord, since, my lord, the paragraph 1 and 2 is clear, my lord, the contradictory, my lord. And regarding the contesting of election, my lord, it has not said that at that time the college was in venture stage. College was granted deficit grants in aid in 1998. They are silent, my lord. It's a biased report, my lord, but that has not been adopted. So, my lord, has got no legal status, my lord. But they have projected these reports now, my lord. Only 2-3 days left to his, my lord, retirement. Now they have raised those.
What do you say about this page 40?
Page 40. Page 40, my lord, as per resolution of the governing body of 1996. But thereafter, the resolution of 1997, the later resolution, which, my lord, appointed the writ petitioner from 1990 as a full-time lecturer. But it is of 1996. Kindly turn to my writ petition, my lord. The order. It is of 1996, my lord. The dates are important. 18 June 1996, page 40. It states that it is with effect from 96 as founder teacher. That word is also important, my lord, that founder teacher, my lord. But his appointment has been given effect to from 1/6/1996 as a founder teacher. Now kindly turn to page 13 and 14, my lord, particularly 14, my lord. 15 is the, my lord, original, my lord, copy, my lord, original copy. The type copy is page 14. Services of Murali Krishna Sharma is regularized as whole-time and founder teacher in the Department of Commerce with effect from 24/8/90. It is dated 1/10/97. That appointment letter was of 18/6/1996. And it is of 1/10/1997. The letter order would prevail, my lord. And it is as per resolution of 1997, governing body resolution. And that was of earlier resolution of governing body. Now that the scrutiny committee, my lord, observes, the second resolution is dubious one. The scrutiny committee goes against the GB resolution. But that resolution was not withdrawn, not modified. That was not communicated. So, my lord, this scrutiny committee's report at page 37 onwards, my lord, does not have any legal status, does not have any legal validity, my lord. At least the writ petitioner should have been given an opportunity to rebut it. They have raised so many things unilaterally, my lord.
What about page 42?
As per, my lord, this order, my lord, 18/6, that date is important, my lord, 18/6/96. Same day, he joined, my lord. He did not have any other way, my lord. He's an employee, my lord. He has been directed that you join since 1/6/1996. So he joined on the same day, my lord, on 18/6/1996 as a whole-time lecturer, my lord. But thereafter, my lord, that 97 episode, my lord, 1997, entire governing body, my lord, deliberated upon this aspect, my lord, and took that resolution, giving him the status of whole-time lecturer since 1990, not 96, my lord. So before your lordship, my lord, there are 2 resolutions, 2 orders. And the later order will prevail, my lord. A query could be made to my learned friend representing the college whether the 97 resolution of the governing body is withdrawn or not, and whether it has been communicated to the petitioner or not. It would come to the arena of the principles of national justice.
What about Annexure E, page 43?
It is, my lord, an order of the Director of Higher Education for regular appointment. So, my lord, that Gangadhar Das sanction or non-sanction, specialized or not, my lord, that teaching experience should be counted, my lord. It is on a regularization order, my lord. Since 2012, my lord. That 96, 90, my lord, orders my lord, regarding whole-time, part-time lecturer. It is regularization order, my lord. That lecturer, Dr. Gangadhar Das, he has been, my lord, serving Cotton College in a non-sanctioned post. And that Dr. Osim Kumar Bose, before the Supreme Court, that case, my lord, a specialized, my lord, course, without any sanctioned post, without non-sanctioned or sanctioned, nothing, my lord. But Supreme Court held that whether it is sanctioned, non-sanctioned, or specialized course or anything, my lord, that teaching experience should be counted. And that resolution, my lord, particularly I'm focusing upon that 97 resolution and order, the latest order. That clearly indicates that I am from 90 and the private respondent is from 92. Meta ends there. And these type of, my lord, wild allegations, my lord, without any, my lord, legal status. Only 3 days left to his retirement, my lord, without giving him any opportunity to rebut it. Can it be accepted in the eyes of law, my lord?
And where's the statement that your PhD degree is doubtful?
My lord, their affidavit, my lord.
Page 24, my lord.
C, page 24, paragraph C. There are 6-7 allegations, my lord. One that contesting election and other things, my lord. Now, C, my lord. May I read, my lord? Page 24. I have rebutted in my affidavit in reply, my lord. The writ petitioner obtained PhD degree from an institute, namely Tikamji University, Bihar, and that university is not included in the list of recognized universities by the state of Assam. It is not mentioned, my lord, it is UGC recognized or not. Very craftily worded, my lord. List of recognized universities by the state of Assam. As a consequence, stage 1 of assistant professorship of the writ petitioner got delayed. Got delayed, my lord, not cancelled. Further, the writ petitioner was appointed to a post which is personal to the incumbent concerned, and as such, the post holding by the writ petitioner will be abolished on his retirement. It does not hold any, my lord, water regarding that UGC, my lord, clause, my lord, UGC regulation. A senior faculty, my lord, whether it is personnel, not personnel, whether that promotional aspect. Now kindly turn to my affidavit in reply, my lord. What is affidavit in reply? My affidavit in reply, my lord. That would clarify the scenario, my lord. Running page 63, my lord. Internal page 4. I did not want to take much time, my lord, since, my lord, that 97 resolution is in my favor. Anyway, my lord, since those wild allegations, my lord, have been made against me, my lord. So, my lord, what is my reply, my lord? Page 63, my lord. Paragraph 5, my lord. May I read? That with regard to the statements made in paragraph number 9, 10, and 11, it is in the paragraph 11, my lord, of the aforementioned affidavit in opposition, while putting the respondents' concern to the strict proof thereof and reiterating the statements made herein above, this deponent writ petitioner humbly states that it is really unacceptable in the arena of service jurisprudence that a college teacher like the present writ petitioner at the fag end of his long service career, who is going to retire from service on 30 September 2024, could be ascribed with such type of stigmatic words, which has been used having purportedly discovered certain incriminating materials against the writ petitioner, that too after receipt of the instant writ petition, without allowing the writ petitioner any opportunity at all to rebut them during the currency of his service period with relevant facts and documents. Next page. It is pointed out that annexure A, B, C to the writ petition as well as the continuation of his service till date without any objection from the respondents concerned would clarify the scenario in this regard. He is still continuing, my lord, without any blemish, my lord, without any objection. Now, my lord, point by point rebuttal, my lord. It would be relevant to point out here, page 64, my lord. 1. There has not been any departmental proceedings and for that matter, any so-cause notice against the writ petitioner in his long unblemished service career, particularly in connection with the purported allegations made in the aforesaid affidavit in opposition. 2. If the writ petitioner is not the founder teacher, then this word should not have been used in numerous official communications so far, and without formal, lawful, and legal procedure, it cannot be opined that a college governing body wrongly recorded him as founder teacher, whose service was regularized as a whole-time lecturer with effect from 24/8/1990. 3. Contesting in an election by a teacher from a venture private college in 1991 has not been barred during the relevant period. The college has got deficit grants in its status in 1998 and afterwards provincialized in 2005. Now, next page. 4. The recent UGC regulations of 2018 has not excluded any college teacher having personnel posts from occupying the post of vice principal as yet. And the interpretation of the respondent's concern of the said provision is not appropriate in tune with the liberal interpretation appropriate to the prevalent welfare state concept of ours. 5. It is regarding PhD degree matters. The writ petitioner's PhD degree awarding institution could not be termed as a non-recognized universities as sought to be projected in the instant affidavit in opposition. Rather, the said awarding university is a UGC or state recognized university. UGC recognized as well as state recognized. 6. It is surprising that the respondent concern could not bother at all to respond the writ petitioner's numerous approaches, even with representations for last several years, but now after filing of the writ petition have suddenly become aware and facts have been discovered while scrutinizing the records in a vilification and smearing campaign against the writ petitioner. Only one thing, since he has not been given any opportunity, he has not been so caused, no departmental proceeding, and he has been allowed to continue till date, without any objection. So, and that 97 resolution that he is from 1990 and private respondent is from 1992. So the first offer should have been made to the writ petitioner. That is my submission, my lord. And lodging and fighting a case against a
with the UGC regulation.
Miller.
UGC regulation.
Miller, paragraph 3, Miller. My writ petition.
The copy of the
copy, Miller.
I have annexed it, your lordship.
In
In my
the-
affidavit in opposition. Page 28 onwards, 28 to 32.
Annexure A, affidavit in opposition. The vice principal, page 32, Miller. The first 4, 5, 6 Miller words. An existing senior faculty member may be designated as vice principal by the governing body.
Okay. Yes.
Lordship, I'm appearing on behalf of respondent number 3 and 4. I'm the principal of the college and president governing body, your lordship. My first submission is that the writ petition is liable to be dismissed on the ground of delay and laches because he was sleeping over his rights, did not challenge the appointment of the private respondent as vice principal of the college, my lord, who was appointed in the year 2021, my lord. And after a period of 2 years, he has approached the honorable court, my lord. Apart from that, your lordship, writ petition is liable to be dismissed on the ground that he doesn't have any indefeasible right
legal as well as fundamental right to challenge the appointment of the private respondent. Lordship, may I take your lordship first to a chart which I could not annex to your lordship regarding the date of appointment of the petitioner as well as the private respondents.
Finish him a copy.
Oh, not okay, yeah. Yeah, this is that. Lordship, chart showing the name of the petition, name of the private respondents appears as serial number 1. Your lordship may kindly note his qualification, his designation, vice principal and associate professor, Dr. Bhababhuti Sharma, and his date of joining in GB approved post is 7/9/92. Your lordship will kindly note that part.
My lord, it has been issued yesterday, my lord.
Maybe, my lord, 7/9/92. And your lordship, the date of appointment of the private respondent, the writ petitioner, 1/6/1996. Your lordship, since he's making the submission, he is the senior most member of the college, my lord, he should be given appointment as a vice principal from the chart which I have just preferred to your lordship, my lord. He's not the senior most member of the college, my lord. There are altogether 4 persons above him, and his name appears as serial number 5. So he cannot claim himself to be the senior most member of the college, my lord, in order to get appointment, your lordship, to the post of vice principal. Apart from that, your lordship, if your lordship considers the qualification part, my lord, the petitioner is assistant professor. He could not cross the efficiency bar, whereas the private respondent is the associate professor. He has crossed class 1 and class 2 grade, your lordship, in a college, my lord. So he is no way comparable to the private respondent, my lord. And lordship, apart from that, your lordship, it's an internal arrangement of the college, my lord. Lordship may kindly look at the GB resolution, my lord, UGC resolution at page 28 of my affidavit in opposition. At serial number 6, page 32, your lordship, regarding the post of vice principal.
Yes.
The lordship, 32. An existing senior faculty member may be designated as vice principal by the governing body of the college on the recommendation of the principal for a tenure of 2 years, who can be assigned specific activities in addition to her existing responsibilities during the absence of the principal for any reason. The vice principal shall exercise the powers of the principal. So it's like, it's nothing. So it's not a lordship constitutional post or something like that. It's a statutory post. It's nothing like that. This post of vice principal has not been lordship incorporated in the statutory rule also. In the UGC regulation is there. It's a totally internal arrangement. So the lordship, by appointing the private respondent to the post of vice principal, which is totally the prerogative of the principal and the governing
By
body.
appointing as vice principal,
My lord,
is there any monetary benefits?
I don't
No,
think
my
so. No.
Nothing, my lord.
No money.
No
Monetary
allowance,
benefits
no
is
benefit.
regarding the grade and scale, scale 1, scale 2.
No,
And
no, that's
no,
not-
I don't.
But being
No,
being
just to manage the affairs of the
designated as a
college.
vice principal.
Only a designation.
Designation. It's not
That-
incorporated into the statutory rules also. The Assam
That appointment
law.
word is also not used, that designation.
Designation.
And where's the order of the respond number 5?
Lordship,
Designating.
30th of November. Lordship, 30th.
Where's that order?
The order is not. Lordship, I have stated in my writ petition, my lord, in the affidavit in opposition, paragraph 4. The writ petition filed by the instant writ petitioner is liable to be dismissed as he has not approached the honorable court with clean hands. The writ petitioner has suppressed relevant material facts while filing the writ petition. Further, he was sleeping over his rights and have challenged the appointment of respondent number 5 as vice principal after more than 2 years. The writ petitioner is not qualified and eligible to hold the post of vice principal, and as such, being unqualified, he cannot pray for exercising a writ.
No, that's a different thing. I want to see the order.
Lordship. Maybe the GP resolution would be there, Lordship.
The petitioner has not annexed, you have not annexed, you have a copy of your order?
Lordship, I'll just get hold of one by WhatsApp, my lord. Lordship, on the regarding the other points, your lordship, regarding his qualification, he went on lien. He was a part-time lecturer, being temporary, he went on lien, my lord. He cannot be the founder teacher of the college because college was established in the year 1983, whereas your lordship, writ petitioners at the time was a student of a college. So he cannot claim himself, although it was the GB resolution who might have committed a mistake. At the fag end of his service career.
Are you saying
My lord,
that there are two GB resolutions?
there are GB resolution. Lordship, I'm not going.
Both resolutions are there?
Lordship, since today I have annexed this one, Lordship, it will stand, my lord. His date of appointment would be 1696.
No, this is not an official document.
Lordship, it's a sign and seal of the principal is there,
Maybe.
my lord. Lordship, because he is at the fag end of his service career, we are not on that.
Do you have any seniority list?
This is the list, my lord. This is the
This was issued yesterday. Prior to this, was there any seniority list in the
With
college?
respect, lordship, I have to take instruction.
This
Because
is the issue.
hurriedly we have filed his affidavit, certain points might have left because his issue is not that, yellows. Now he is making a avenue for his future, like because pensionary benefits and we may not enter into all this aspect of the matter, our college authorities, since lordship, he has filed a writ petition.
No, what he's saying.
My lord.
He's saying that he's senior to the respondent number 5.
My lord.
And he's claiming his seniority from 1990. And the respondent number 5, he's
My
saying that his seniority is to be counted from 1992. So 1992, you have rightly reflected in this chart.
My lord.
That is fine.
My lord.
But so far as the petitioner is concerned, 1/6/1996.
Six.
Now, to see who is senior.
My lord. At the face of it,
Obviously,
the private
so
respondent.
that there would be a seniority list issued by the college authorities.
Seniority list,
In
I
that
think.
list, if his date of joining is
My lord.
indicated as 1/6/1996, and he has not bothered to challenge that 1996,
Lordship.
then everything, all the matter is over. That's
No,
all.
my lord, one more aspect. That gradation list and seniority list will come departmental wise, my lord, department wise. This is, lordship may kindly see the department. My department is management. His department is finance, my lord, Murali Krishna.
No, that's fine.
My lord.
It may be
My
department,
lord.
but his date of counting seniority would be reflected.
It would be reflected. It would be reflected.
That
But
is
you
what
know,
I
at the face of it, 96 or 97, I am far more senior because my date of appointment is 1992, my lord.
He's claiming 1990.
My lord.
He's
Or
claiming,
1990.
and to that effect,
My lord.
he has also annexed an order
Lordship,
issued by the secretary.
Lordship, once seniority will be counted to a sanctioned post, not a part-time lecturer or something temporary post. Once the post is created, the college has to be provincialized, my lord, and the post will come, your lordship.
Have you read that order annexed by the writ petitioner, which shows that he's as a whole-time lecturer and a founder member will be with effect from
Lordship,
24/8/1990.
Lordship, my humble prayer, your lordship may not go into that aspect of the matter. Why, your lordship? Because let us take his prayer portion, my lord. His prayer in the writ petition.
That
What
I've
is prayer?
That
my
I've
lord.
seen.
His prayer is any other appropriate so shall not be issued for appointment, engagement, designation or writ petitioner as vice principal of the KCDS Commerce College with retrospective effect and or for setting aside quashing the appointment, engagement of designation of the respondent number 5. Lordship, may kindly have one look. Yes, sir. So, your lordship,
2021.
my lord,
When did you file your writ petition?
September 2024. Lordship may see memo so and so 5/9/2024.
20 August 2024, isn't that?
Writ petition has been filed on 19th August, my lord.
Lordship, regarding the other aspects regarding his PhD degree and all, I don't want to comment. It's subject to
We are
record.
not going into that because
Lordship.
you have not given him any show cause, nothing. This
Lordship,
second of the
that's correct.
we're not.
My lord, and
Only
regarding
thing now is,
My
only thing now is
my lord,
the interpretation of that clause
4-6 EGC.
of the UGC.
yes,
That is,
whether he is the senior or he is the senior most.
yes, clause 4.
Clause 4 of UGC regulation, it doesn't say it should be given to the senior most member. It says, my lord, it should be given to the senior person, my lord. Lordship,
It says
please see.
an existing senior an existing senior faculty member.
My lord,
An existing.
lordship,
An
but doesn't
existing
say
senior
senior
faculty.
most.
No,
Say
it does
senior
not say senior most,
my lord.
but it says an existing.
Existing senior person.
Senior
So
faculty.
existing senior most and existing senior are two different aspects,
So-
different words. Since even if your lordship takes his words, his date of appointment is 1990, he may be senior most, but rule doesn't say so regarding the, my lord,
While interpreting that clause 4.
my lord.
Now, this court also would like to see whether you have issued any seniority list of the lecturers in their respective departments.
That I have to take instruction.
And showing the date,
Government-
counting of the date of seniority from so and so date.
Yes, my lord.
If in that seniority list, if it is reflected as 1996,
Lordship.
and he has not challenged the seniority list in date,
My lord.
then nothing will survive in this
Lordship.
petition. But if you have shown his date of counting seniority with effect from 1990, then all your submissions also crumbles.
Lordship, but still, I think I have a case. Why, your lordship? Because this writ petitioner has not come up with all the documents which is available with him. It might be because he should come with clean hands before this honorable court in order to avail writ jurisdiction, my lord. And your lordship, on the point of delay, your lordship.
That part
My
I've
lord,
noticed.
I want to
No,
cite one judgment.
that part I've taken note.
Lordship. And another aspect, your lordship, regarding his legal right, this honorable court judgment I'll be referring to, your lordship. It's reported in 2007, 2GLT 87. And regarding delay, 2024 live law SC 318. Honorable Supreme Court has interfered with the matter, did not interfere with the writ petition, lordship, on the ground of delay and laches, even if he is a valuable right, your lordship. I'll be relying on 2024 live law SC 318, para 9, your lordship may kindly have a look.
Which one?
Para 9, 2024 live law SC 318, para 9.
Yes.
Having heard rival contention raised and on perusal of the facts obtained in the present case,
1 minute.
my lord.
Oh, okay.
Having heard rival contention raised and on perusal of the facts obtained in the present case, we are of the considered view that writ petitioner ought to have been non-suited, or in other words, writ petition ought to have been dismissed on the ground of delay and laches itself. An applicant who approaches the court belatedly, or in other words, slips over his rights for a considerable period of time, wakes up from his deep slumber, ought not to be granted the extraordinary relief by the writ courts. This court time and again has held that delay defeats equity. Delay or laches is one of the factors which should be borne in mind by the High Court while exercising discretionary powers under Article 226 of the Constitution of India. In a given case, the High Court may refuse to invoke its extraordinary powers if laxity on the part of the applicant to assert his right has allowed the cause of action to drift away and attempts are made subsequently to rekindle the lapsed cause of action. The discretion to be exercised would be with care and caution. If the delay which is occasioned in approaching the writ court is explained, which would appeal to the conscience of the court, in such circumstances, it cannot be gainsaid by the contesting party that for all times to come, the delay is not to be condoned. There may be myriad circumstances which give rise to the invoking of the extraordinary jurisdiction, and it all depends on facts and circumstances of each case. Same cannot be described in a straitjacket formula with mathematical precision. The ultimate discretion to be exercised by the writ court depends upon the facts that it has to travel or a terrain in which the facts have traveled. For filing a writ petition, there is no doubt that no fixed period of limitation is prescribed. However, when the extraordinary jurisdiction of the writ court is invoked, it has to be seen as to whether with a reasonable time same has been invoked, and even submitting of memorials would not revive the dead cause of action or resurrect the cause of action which has had a natural date. In such circumstances, on the ground of delay and laches alone, the appeal ought to be dismissed or the applicant ought to be non-suited. If it is found that the writ petitioner is guilty of delay and laches, the High Court ought to dismiss the writ petition on the sole ground itself, inasmuch as the writ courts are not to indulge in permitting such indolent litigant to take advantage of his own wrong. It is true that there cannot be any waiver of fundamental right, but while exercising discretionary jurisdiction under Article 226, the High Court will have to necessarily take into consideration the delay and laches on the part of the applicant in approaching a writ court. The court, in the case of Tridip Kumar Dingal and others with State of West Bengal and others, 2009 1 SC 768 has held on the following affair. We are unable to uphold the contention. It is no doubt true that there can be no waiver of fundamental right, but while exercising discretionary jurisdiction under Article 32, 226, 227, or 136 of the Constitution, this court takes into account certain factors, and one of such consideration is delay and laches on the part of the applicant in approaching the writ court. It is well settled that power to issue a writ in a is discretionary. One of the grounds for refusing reliefs under Article 32 or 226 of the Constitution is that the petitioner is guilty of delay and laches. If the petitioner wants to invoke jurisdiction of a writ court, he should come to the court at the earliest reasonably possible opportunity. Inordinate delay in making the motion for a writ will indeed be a good ground for refusing to exercise such discretionary jurisdiction. The underlying object of this principle is not to encourage hesitation of stale claims and exhume matters which have already been disposed of or settled, or where the rights of third parties have accrued in the meantime. Then the next paragraph, Your Lordship, there is no upper limit and there is no lower limit as to when a person can approach a court. The question is one of the discretion and has to be decided on the basis of facts before the court, depending on and varying from case to case. It will depend upon what the breach of fundamental right and the remedy claim are and when and how the delay arose. It is apposite to take note of the dicta laid by the court in Karnataka Power Corporation Limited and others versus K. Thangapattan. Then violation of legal right, my lord, may I refer 2007 Rule GLT 787 for Honorable Justice Steve Hyper J. deliberative judgment, my lord. Lordship, para 3. Has your lordship got it?
Yes.
The question of locus standi again came up for consideration before the apex court in Ghulam Qadir Supra, a case cited by the Learned Counsel for the Respondents University, while duly noting the recent far-reaching changes in the orthodox rule of interpretation regarding locus standi. The apex court observes at para 38 of the judgment as follows. There is no dispute regarding the legal proposition that the rights under Article 226 can be enforced only by an aggrieved person, except in the case where the writ paid is far habeas corpus or quo warranto. Another exception in the general rule is the filing of the writ petition in public interest. The existence of the legal right of the petitioner, which is alleged to have been violated, is a foundation for invoking the jurisdiction of the High Court under Article 226. The orthodox rule of the interpretation regarding the locus standi of a person to which the court has undergone a sea change with the development or constitutional law in India, and the Constitutional Court have been adopting a liberal approach in dealing with the cases or dislodging the claim of a litigant merely on hyper-technical ground. If a person approaching the court can satisfy that the impugn action is likely to adversely affect his right, which is shown to be having source in some statutory provision, the petition filed by such a person cannot be rejected on the ground of his not having the locus standi. In other words, if the person is found to be not merely a stranger, having no right whatsoever to any post or property, he cannot be non-suited on the ground of his not having locus standi. Thus, the question whether a person has the locus standi to bring a proceeding under Article 226 of the Constitution depends on mostly whether he possesses a legal or fundamental right, and whether such right has been violated. The well-known recognized exception are a writ of habeas corpus or writ of quaranto and a public interest litigation. No other exception appears to have been developed as yet by the apex court. The enormity of the infringement of laws by the authorities is hardly relevant for determining the right of citizen to invoke Article 226 unless it's personally aggrieved by the action or inaction of the authorities. The proposition of law is also consistent with the proposition that the petitioner must succeed on the strength of his case and not on the weakness of the case of his opponent. In my opinion, this fully takes care of the submission of the learned counsel for the petitioner that for determining the standing of the petitioner, this court should examine the merits of this case. I have carefully gone through decisions of K. Shekhar Supra and D.C. Wadhwa Supra, upon which heavy reliance was placed by learned counsel for the petitioner. In K. Shekhar Supra, one of the questions called for consideration before the apex court was whether respondent number 1, therein did not have the locus standi to challenge the appointment of the appellant either as lecturer in 1986 or subsequently as assistant professor in 1990 in the National Institute of Mental Health and Neuroscience, not only because she herself had not applied pursuant to the advertisement dated 29 and 86, but also did not have the necessary qualification to be appointed to either post. The contention of the respondent number 1, on the other hand, was that the Nimhans had appointed the appellant as assistant professor by the backdoor and method contrary to the recruitment rules of so-and-so. Then your lordship, I'll skip the other part. I'll take your lordship to paragraph 5. The findings recorded herein that it is nobody case that the respondent number 1 could not be considered for appointment as assistant professor in 1990 is instructive. I fail to understand how this case can be of any assistance to the petitioner wherein the respondent number 1 in K. Shekhar Supra was found to be qualified for the post in question. Therefore, this decision does not lay down any proposition of law, even remotely suggesting that a person who is neither eligible nor apply for a particular post has the locus standi to challenge the appointment of third person. Coming now to the second case cited by the learned counsel for the petition, namely D.C. Wadhwa case. It may be noted that there were 4 petitioners in that case, and the case has been discussed, my lord. Now I take your lordship to next page, my lord. 5.1. Reading the proposition of law laid down in D.C. Wadhwa case and the observation made in S.P. Gupta case extracted above in juxtaposition in my considered view unmistakably reveals that the law of standing that only a person whose legal or constitutional right has been infringed can maintain a writ petition still holds good, and the grievances ventilated by the petitioner number 1 D.C. Wadhwa case were allowed to be raised as a public interest litigation and not as the ordinary writ petition. That is why the apex court has time and again warns the judgment of a court of law should not be read like Euclid's theorem. The court, it is neither minor. So my respectful submission that since he is retiring in
Would you get any instructions with regard to the seniority?
seniority. Tradition is offensive.
Whether any
The college.
letter seniority list?
My lord. So since he's retiring in 2 days, my lord, lordship, he was sleeping over his rights. He doesn't have the qualification. Lordship, can he file a writ petition challenge the process of appointment of the private respondent, which is totally an internal arrangement of the process. So on that ground itself, on my law, on the ground of delay and
On the issue of delay, yes.
lordship, his petition may be dismissed.
You have
That
a-
is my respectful submission.
When was the first representation you made?
Nine 5/2023. Page 16.
That was the only representation?
Milord, earlier to that, Milord, 1/11/2021, that reference, Milord. And my numerous approaches, Milord.
No,
It is only-
nothing, my lord.
This annexure C,
Nothing has
Milord.
been- 95/2023 he has annexed, but other representation is not annexed.
But I have referred, Milord, my earlier representation dated 9/11/2021. Page 16, Milord. And I have stated in my writ petition also. Milord. regarding delay part, my lord, is completely discretionary jurisdiction of this honorable court. My right versus the college authority's right. And my stand is that, my lord, still I have 3 days to go, my lord. It's a, my lord, of the record, my lord, ego problem, my lord, between the principal and the writ petitioner, my lord. That is why, my lord. That is why, my lord, so many
He takes
allegations.
permission to undergo refresher course. He cannot complete and comes back. For that reason,
I'm not going.
Lordship.
Did you get?
Lordship, to my instruction, my lord, they do not have any accreditation list. It's from the personal files, everything has been extracted, my lord, and it was at the last minute, this one chart has been prepared yesterday.
This has been taken from the personal file?
Yes, my lord. Official records of the college.
Always one aspect will be there, my lord, whether preparing the seniority list, whether it has been done surreptitiously, whether it has been communicated to the writ petitioner, my lord. Since, my lord, there is something between the principal.
Since I am making my submission on the
My lord,
basis of the telephonic
otherwise, my
instruction,
lord, it should have
that
been
they
in
do
the
not have.
website of the college,
He should be
official website.
available in all the
No, what
documents.
she's saying is that there's no seniority list.
My lord. And
Now
yesterday,
the only thing is now there are two governing body resolutions.
My lord. Lordship, from there, Lordship, after hearing the submission of my learned senior friend, is also my chamber colleague. I have the privilege to fight against him today, my lord. Lordship, he is making a way for his future, because he'll be retiring. Maybe he has the apprehension, my lord, that there might be some problem while getting other benefits. Maybe
Lord,
for that reason only.
no financial
Because I don't
benefit, my lord.
find any legal violation of any legal right or the fundamental right. Because it's totally an internal arrangement made by the college authorities.
My lord, these are of the record statements, my lord, that I'm constrained to, my lord, reveal. Today morning also, my lord, the writ petitioner communicated with me some documents, my lord. And his stand is that that his pensionary benefits may be stalled, my lord, in view of, my lord, filing this writ petition, my lord. So, my lord, so many other things are there, my lord.
It's
So
all apprehension.
that is why, my lord, he has
Maybe-
come late, my lord. That is, my lord, one
That there's no explanation
my lord.
given.
So,
Okay, I'll pass orders.
No, simply operates.
Writ petition is dismissed.
most obliged.
6 of daily leave. Admission.
I'll pass orders in the chamber.
Let me. I'm not there in this case. My colleague is there. My friend may start. I will ask him to come down. Let my friend start.
Lordship, may I start, my lord? I'll pray for final disposal of this case.
What is this matter?
My lord, it pertains to the termination of the PhD studentship of the petitioner, your lordship. He was terminated in 2019, your lordship.
Hmm.
He came in 2010. The litigation is ongoing, my lord. So
What is it?
he was terminated. He was a PhD student at IIT Guwahati. He was terminated, my lord, in 2019. Thereafter, we have come before this honorable court challenging the termination.
Okay.
So if I may proceed, your lord.
Where's your friend? Is it the Sutata?
Yes, my lord. He is. And Mr. H.K. Das is there, my lord, probably, for the private respondent is there. The allegation is very broad item, my lord. There is some allegation is against private respondent represented by Mr. H.K. Das.
Oh, some private respondents?
Yeah,
Yes.
Das is there.
1 minute. Respondent number 4?
Lordship.
Yes. Who is this? H. Das.
My lord, I'll try to reach out.
Okay, 1 minute. Hold on, counsel. In the tweet petition, I have not recorded, will be MS D Buyan, no? The first one will be PG Fukan for the petitioner. MS D Buyan, the senior counsel, assisted by whom? Vibra for the respondents. ERF. Give the file, the earlier file. Just a minute, I forgot something.
Hey, that's for.
As we are. Standing Council Higher Education 1, 2. Then B Buyan, assisted by B Bura, 3 and 4. And respondent number 5, that also S Buyan. Okay, that is also S Buyan.
No. Sir, Mr. is just for a no.
No. Are you sure? Okay, S Buyan for respondent number 5. Huh? I'll dictate. Yes. Are you ready?
Yes, Lordship. I'm ready, but this matter will take some time, Lordship. Because I have to show all the documents to your Lordship. If my learned friend wants to start this matter, then it's up to my learned friend.
So, we are also ready. We are for respondent 4.
No, for learning facility that is on legs. For another opportunity.
Okay, then we'll proceed. Good. Yeah. Oh, that's 5 minutes.
Lordship, yet to call the petitioner Lordship. We have submitted the order.
The process is going on, my lord. Okay.
My lord, only problem is that Lordship, in the meantime, they may fill up the post, Lordship. In the interim, your Lordship has directed that result of the.
No, my lord. Interim, already there, my lord. On interim is there and he is
Subject to the
yeah.
Third name council on request made by U Sharma and the Standing Council Secretary Division. This is the matter after the puja application. Yes.
18.
Yes, Sharma. Headmaster.
My lord, here is a issue is slightly different, my lord, that we did not take the NOC for obtaining the BA degree. So that is different, but the category of post is same, my lord. Promotion affidavit is required, my lord.
NOC, that already the court has decided.
This degree cannot be held invalid, my lord.
That's your agree?
I'm appearing, your lordship. Let us file affidavit, your lordship. Let us allow to file our
Yeah,
affidavit.
we are on a conservative on request made by B Das, the Standing Council, Secretary Division. 2 weeks time is allowed to file at least after puja.
But may I pray for a fixed date, my lord?
So that is the issue after the
Vacation, my lord, any date, my lord.
difficult. You can make your mention and then we'll list it.
Mal. Oblige.
43 of supplementary list admission.
This matter may be passed over for the timing.
Is there an interim order here?
Yes,
What is the interim?
my lord, to keep a set seat, my lord.
Where's that,
vacant.
where's that order?
In the IM, my lord. Already passed in the IM.
Yes. Bora?
My lord, I am for the state only, my lord, regarding the admission. If he succeeds in the repetition, then we will provide
Okay.
admission.
Basically, my case is with the NEET, my lord, NTM.
Who appears?
Mr. Gupta is on legs, my lord, in court 25, my lord. After some time, my lord.
After some time? Oh, you want it after puja?
No, my lord, after that it will be difficult because the admission process will be over, and once it is there is an interim order, my lord.
So
Regarding
you keep that one seat vacant. Let's see what the NEET.
Out of 650 seats, my lord, only one seat.
Okay.
But
After some time.
yes, my lord, after some time.
Problem.
9 to 14 of daily list.
Quickly. So the record that here, my lord, the landed advocate general will appear. But he's on legs, my lord. Possibly this will take some time, my lord. But she will take up after the vacation immediately on.
My lord, the matter is adjourned on this ground, or are there any, my lord, there is an interim order in our favor?
Yes, interim order is there.
Is it absolute?
Yes, yes, still disposal of.
Still disposal.
Yes. Yes, sir.
Okay, heard the learned counsels appearing for the petitioners. On request made on behalf of Mr. D. Saike, learned Advocate General Assam. List the matter up to the puja petition.
My lord, my prayer would be to fix a date, my lord, because our age is going, my lord. Maybe by the time the matter is decided, some of us may.
Issue is, I've already told the bar,
My lord.
I'm not fixing dates up to puja because all the cases will come in.
My lord.
So you can make your mention and then we'll get it listed.
My lord.
My lord.
Order.
Your lordship may kindly peruse the last order dated 20th of September.
Yes.
My lord, may I take your lordship to an earlier order dated 19/6/2024, 19th of June. My lord, in the similar situation, my lord, this honorable court was pleased to direct the personal appearance of some officers. They appeared on 21st of June. And thereafter, immediately, my lord, they released for some time. Surgery.
That helps.
Therefore, my
After
lord,
that again they stop.
my lord, let my lord, at least the director of my lord, DEO appear personally, my lord, then your lordship will know what is the actual position.
With the council, he was
This
here.
attorney was here, my lord, a little while ago. This is a quantum of 2018, my lord. Once, my lord, there is an order to appear personally, my lord, everything falls into place. Everything falls into place.
And once it is dispensed, then again they go back. Yes.
Second, after some time, Mr. N. Khatunia's name is there. 1911. After some time, Lordship.
He was here just some time back.
I'll call.
Do you have any information? What is your salary?
No, my lord. In fact, the last information is that, my lord, the district elementary education officer says, my lord, I have been instructed not to release the salary. But there is no, my lord, official communication. It is verbal order only. That's why, my lord, if he appears personally, he'll explain, my lord, what has happened. I am not praying for the appearance of other, my lord, respondents right now. Only, my lord, the.
NG Khatanier is appearing, your lordship. He is there, your lordship. He is on legs. He is coming, your lordship. Kindly pass over the matter for time.
Okay, just
After
My lord. They're playing with the court, my lord.
20 to 23.
My lord, so senior counsel, Mr. Kane Chaudhary is on legs in court number 1, my lord. Kindly pass over the matter for the time being. my lord. After some time.
Why is it coming for orders?
My lord, the affidavit was not filed in the last occasion, my lord. The department counsel has said he will argue on the law points, my lord. Since the, my lord, 2 review petition already dismissed by this honorable court challenging same advertisement, my lord. So. Yeah.
Oh, that 21/3/2023.
Yes, my lord, 2020. Technical, my lord. Legal entry.
So you want to take up after some time?
My lord. Obligation.
Nineteen.
My lord, a friend has come.
Then let the DO appear. Heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. M. Datta, learned counsel for the petitioners. Mr. N.G. Katania, learned counsel appealing for the respond number 4 and 5. Has furnished a communication dated 25th September 2024, written by the Director, Elementary Education Assam, wherein it is stated that the Block Elementary Education Officer, Lahari Khat, being the DDO, is responsible for release of salary of the 20 petitioners. It is also stated that no instruction was issued to the PEO Lahari Khat to stop salary of the 20 petitioners from the month of July 2024 from the directorate stop. Accordingly, the Block Elementary Education Officer, New Paraha, Lahore Kutch. Is he a party here?
He's not a party, man.
He's not a party. Is directed to appear before this court. It has to come after the puja vacation.
My lord, is a question of, my lord, salary.
But then the time factor.
I leave it
How
to-
far is Lahari? I don't know where is Lahari.
It's Morrigaon, my lord. 1.5 hour journey, my. My lord, that order itself will be enough, my lord, for release of the salary. The direction of person level. So let it be, my lord, if possible, before the holidays. My lord.
Can he come by third?
My lord.
Yeah, on 3rd of October 2024. List the matter on 3rd October.
Yes, finally, bless.
24 to 34 and supplementary 39 to 51.
May I please, Your Lordship? Your Lordship, today we have filed 6 affidavit, Your Lordship, affidavit in opposition. And the other one, we need to take instruction. And beforehand, Your Lordship, I would like to draw your attention towards one matter regarding with petition number 46775 2024 that plays on DB bench yesterday. And particularly that is arising out of same issue. And now they are challenging that, directly challenging the rules. Here, they have said that they are aggrieved from the rules. So let the matter may solve, Your Lordship, in the decided in the division bench, Your Lordship. I would like to draw
Who filed
same
the?
petitioners,
Who-
Dwijendra Nath Sharma and 11 others. I would like to place, Your Lordship. There, Your Lordship, notice has already been issued and it will list in the month of November 2024. I would like to place before you, Lordship.
My lord,
Arising out of same.
my lord, I have
One
filed.
minute, let me see.
AK,
একেই নহয় বেলেগ বেলেগ আছে
AK,
কেনেকে হ'ব?
AK, DB গৈছে.
DB
Same petitioners.
is in connection with the validity of the rule, my
Promotions
lord.
with respect
And
to
here
the
in connection
service
with
of
the,
teachers.
in connection with the process of the promotion process. Two distinct subject, my lord. One is for the single bench and one is for the division bench. That cannot be clubbed together. DB will not decide the issue of whether illegality and legality is there in the process of promotion. DB will decide, my lord, whether the validity of the rule is as per constitution or not. Here they have to answer, my lord, whether the science graduate teachers of the upper primary schools after amalgamation, where they are eligible to be promoted to the post of headmaster. They are supposed to file affidavit on that point, specific point only, nothing else.
Where have you filed your affidavit?
Your Lordship, today, Your Lordship, we have filed 6 affidavits, Your Lordship.
In
And rest clubbed
which matters?
with petition 402224.
Give me the serial number.
He has filed in item number 26 to 31, madam.
Other parties
And these-
provided copy of the affidavit.
That is item 30, Your Lordship, 4022/24. Then, Your Lordship, 4024, 31. Item 30, 31. Thereafter, Your Lordship, 4021. 2129. Item number 29. Then 4019, that is item 28. Then 4017. That is item 26 and 14018. From 26 to 31, Your Lordship, our affidavit has already been filed, Your Lordship. And rest club matters, Your Lordship.
That is in PG Bora's case.
My matter, madam.
In
Your
yes.
case.
26 to 31.
And in Purkayasta, Guyan,
We are left out, my lord.
and Mammoth,
We are left.
you are left out.
We are left out.
My lord, I am sorry to interrupt you, my lord. My lord, what has happened on the last occasion, my lord, our submission was very limited, my lord. That they are saying, not in a black and white, that those science graduate teachers, my lord, who had been amalgamated by virtue of the amalgamation, my lord, their past services cannot be counted. Now, my lord, we have demonstrated from the rule, my lord, as well as the various judgment that the law is already settled, my lord, that the past services is countable, my lord. Now, that's why my lordship was pleased to, my lord, make a specific query to answer through an affidavit, my lord, that whether these science graduate teachers are entitled to be promoted or not, and whether the department is going to be considered. My lord, although in my case, no affidavit has been filed, but I have gone from my respected friend's affidavit, my lord. I have not seen any of the averments they have made. My lord, they are playing, my lord, hide and seek. My lord, they should come up with a, my lord, clear stand that yes, we are going to
will not promote the science graduate teacher, or we are going to reject them for this reason. And on the other hand, Milord, behind our back, they are proceeding with the selection. In the Milord, the director of secondary education list has also been finalized. It has been sent to the government for approval, and within very short date, Milord, promotion order will be issued, Milord. Keeping us,
Has
my
not
lord.
been taken place, your lordship.
No,
It
that
was
is correct. I have not said,
not-
I have not said that
The
promotion
result
has
is
been
not
taken.
out, your lordship. That declaration is yet to be.
That is
came out,
correct.
your
That is
lordship.
correct. But it
finally-
has been finalized, Milord. That has been
Finalized list has not been published, your lordship. That thing, your lordship, we are also not aware.
There
So
is
my-
interim order last day, lordship.
My lordship has protected us till today, Milord.
So till today. Till today, lordship has directed no finalization by the state. That is up till today.
Who is that interim?
My lord, may kindly peruse the order
last
dated
order.
21.
20?
Last order. তুমি দেখাইছিলে না? My lord, may kindly peruse the order dated 9/9/24, Milord.
One.
Mm.
9/9/24.
My lord.
In which case?
My lord.
Here there's no 9/9/24. Okay, okay.
WPC, Milord. Common order, Milord. It starts from IS civil number 2345. That is in my case, Milord. WPC, Milord. Item 24, Milord. Today's list, item 24, 3116, Milord.
With other link cases, all are link cases numbers are there.
9/9/2024.
My lord, my lord. A submission has been recorded of my respected friend that it has been asserted before the court, Milord, that it will not be finalized till today, Milord. So that may kindly be extended, Milord.
Extended, and my lord, the state should not be given a delaying tactics. They are only delaying tactics. They are instead of disposing the matter one times after times and in this manner.
Your lordship, this is the clubbing matters. After that matter has came up, your lordship, some other matters has tagged. So your lordship, already six affidavit has already been filed, and other in other matters also we have filed in that Ramesh Chandra Kakoti. That all affidavit is already been filed, your lordship. So now another some matters have clubbed together, your lordship. For that, your lordship, we need to seek instruction.
No, that's
and
fine. That's fine. That's
adherence-
fine. I'll
and
give you time.
examination is also going on, your lordship.
I'll give you time. I'll give you time for filing affidavit in the other petition. How much time do you require? That's what I say.
Kindly list this matter, your lordship, in the month of November, your lordship. At the same time, your lordship, this matter will also come up.
Division bench issue is totally different, Milord.
They have no issues because already interim protection has been granted.
There is no
to them.
direct stay is there, Milord. Only my respected friend submission had been recorded, Milord, that the till day that the selection will not be finalized, Milord. That's the interim protection. So if my lord may be pleased to observe that without the leave of the court, Milord, they will not finalize the list, Milord. That interim protection may
This-
kindly be provided, Milord.
This DB matter, your lordship, fresh notice has issued.
That is a different
And
issue,
this is
Milord.
the same petitioners.
Okay, I'll give you time, 3 weeks time to file affidavits. And then I will list it after the puja vacation. Till the returnable date, don't finalize
My
the
lord.
selection process of the headmaster.
My lord.
Okay. Third, the learned
And in
council.
the month of November, your lordship. Because
no,
some
we'll
other members.
We'll list it after the.
If lordship may permit me, your lordship will see order dated 21/8/2024 in that miss case, my lord. 21/8/2024. The last third paragraph from the bottom, my lord. In this said affidavit, the respondent number 2 is also directed to make its stand clear with regard to the allegations made in WPC 4017/2024. The respondent number 2 shall also make its stand clear whether the science graduate teacher of the various schools are also eligible for being considered as graduate teacher for the purpose of promotion to the post of student. They have filed the affidavit today in the 6th. They have not spelled out a single word
Okay,
regarding
then
this.
it's up to
So
the-
they have to spell out this.
Third, the learned council for the petitions. Stop. MS B Das, learned standing council, secondary education department submits. That you have filed already?
Already, your lordship, pertaining to item number 20.
No, that's why. Have you filed or you're going to file?
No,
They're
ma'am,
going
we
to
have
file.
filed.
They have served a
We
copy.
have
That-
filed.
Yeah.
The copy has already been
That
served.
she has filed affidavit in WBC number 4017/2024, comma 4018/2024, comma 4019/2024, 4021/2024, 4022/2024, and 4024/2024. Today, stop. She prays for further 3 weeks time to file affidavit in the other writ petitions. Praise the Lord. This after after the puja vacation. Stop. Till the next returnable date, comma. The respondents are directed not to finalize the selection process with regard to headmasters of various schools,
High school.
of various high schools without the leave of the school.
Your lordship, today some matters has clubbed together, your lordship, that has been tagged. Your lordship, pertaining to that matter, your lordship, extra copy may serve upon us, your lordship.
My lord, item number 39 and 40, my lord. Motion matters today. Item 39 and 40.
Yes.
Similar matter, notice may be issued.
Give me 30.
Wait.
1 minute.
39 and 40.
39 and
Third, Mr.
B Prasad.
B. Prasad and the counsel for the petition. Issue notice.
Extra copy.
MSP does, then the standing council, secondary education affairs for the respondents. 1, 2, 3, 4, 5, all.
No, except one, my lord, except number 5, my lord. He is deputy commissioner. For state government, he will take my lord.
No.
My lord,
I will
respondent
not
number 4.
appear, I
Respondent
will
number
not appear for respondent 5 till 1,
Four,
2,
four.
3, 4.
1, 2, 3 and 5.
1, 2, 3, 5.
Right.
3, 5, no. 5 is for higher secondary.
Hmm.
Higher secondary. Higher secondary is another council,
Okay.
Mr. I am for secondary.
What is of secondary? What's of secondary?
Higher secondary is secondary. Higher secondary is.
Higher secondary. Okay.
Oh, 1 to 5
1,
years.
2, 3 and
Yet
5.
the early order passed by this court.
My lord.
1 to 5, isn't that? 4.
1, 2, 3.
1, 2, 3 and 5.
How about 4?
4 state government standing council. Government advocate. Deputy commissioner, deputy commissioner.
No, not this.
Earlier in 4017, my lord. This is regarding interim, my lord. 4017, item 26.
You want this order?
Since your lordship has already granted that they will not finalize, let that be applicable in this case also.
39, 40, no?
13.
You responded 4. 39 to.
Notices were issued in this case, 1, 2, 3 and 5. 4 government.
Paid us for respondents 1, 2, 3 and 5 and 4. Mr. B. Devril and government advocate for the respond number 4. Notice and respondents are complete, however, extra copies. Respondents are allowed to file affidavit. List after 4 weeks.
After 4 weeks.
Till the next returnable date. Respondents are directed not to finalize the selection process of headmasters of the
Without the leave of the-
of the different high schools without the leave of the school. And then item
39 and 40, same, my lord. Same, my lord. Same,
40.
will be same.
10 respondents,
Same respondent, my lord.
same order.
If you obliged.
Let it, these matters be tagged with.
Those are coming after 3 weeks, you're coming after 4
4
weeks,
weeks.
so let it come up on this.
No issue. Okay.
My lord, item number 16 is also similar, my lord, not tagged with the series, my lord. Item number 16, my lord.
Item number
16. If you tagged with the, my lord, item number 25 or 24. my lord.
16 orders was already passed.
Yes, passed, my lord, they're not tagged. The same letter, my lord, they come on the same date, my lord, along with it. Therefore, it will be tagged, my lord.
No, we'll pass orders separately later on.
Obviously.
What about 41? It's the same matter.
Your pleasure, Lordship. Lordship, item number 41 of supplementary, my lord. My lord, this matter is not similar, my lord. My lord, petitioner pressed for the similar order. In WBC number 4530/24, my lord. Order dated 9/9/2024. That relevant page number, my lord, 22, my lord.
Hailakandi, is the process complete or still going on? Third, Mr.
Arrive here.
Arrive here and then the council for the petition. Issue notice. MSP, that's the next standing council.
Hailakandi, your lordship, document verification in respect of recommended candidates of district selection committee has already been held on 5/8/2024.
Oh. Appeals for the
Already, that has done, your lordship. 5/8/2024.
Secondary education appeals for the respondents, 1, 2. And who's this private respondent?
Respondent number 4, my lord. Surya Prasad Sharma, he is a present headmaster, my lord.
Why do you want to implicate him?
Yes, sir, very documents of what is about.
My lord, relevant page number 12, my lord, serial number 1, Surya Prasad Sharma, my lord. He is a
One idea. Listen.
12. Respondent number 4, who is junior to the petitioner holding the post of the headmaster, my lord.
Who is the order appointing the respond number 5 for?
Appointment letter.
Appointment letter, my lord. That is page number 13, my lord, dated 30/11/1991.
That is the petitioner appointment letter, but the person, your lordship, where that private respondent letter has not been annexed.
Where is that appointment order?
Appointment order of a private respondent.
I see 2 years.
Fresh file COVID.
Let matter will pass out for the day.
On request made by Mr.
Arrive here.
Arrive when, then council for the petitioner. Matters passed over for the day. We list it on a date, list the matter on first.
Yes, sir.
Thursday.
20 to 23 admission.
Lord, this case, Lord, AG will appear, my lord. His legs in court number 1 and Mr. K. Gogo is also legs in court number 27, madam.
That you didn't mention in the, when the matter was called up earlier.
That time was, you know, now I have seen voter legs. Two different court.
The only thing is, my lord, there was no stay. Now, what has happened? We were appointed under regulation 3F. Now the post has been advertised. Now, if the posts are filled up, where do we go, my lord? Therefore, if the hearing of the matter is to be deferred, for whatever reason, my lord, eventually if we succeed in the writ petition, then my lord, there must be some interim protection, my lord. At least that the selection would be subject to outcome of the case. Something has to be there, my lord. Otherwise, my lord, there is absolutely no interim order. And otherwise, my lord, this is covered by a judgment of a coordinate bench of this honorable court. Because matter is very simple, my lord. Again, sanction post advertisement, 3F appointments were made. Because, my lord, 3F appointments can be made only to a post, not a sanction post, to a temporary post. There is a judgment of our High Court. It's a reported case. Otherwise, I am covered by that. On earlier 2-3 occasions also, my lord, same thing happened. Either AG is not there. Even my lord, in the item number, I was there in court number 27. There also, because AG is not there, matter has been deferred. So therefore, my humble submission is, my lord, some protection must be given. That the selection would be subject to the outcome of the case. At least something, my lord. Then matter can await. Otherwise, it will be difficult.
Yes, Das.
Kindly talk about it. Regarding this position. Otherwise,
Okay, now there's no time. We will take up at 2. Are you free at 2?
Little late, my lord. Around 3 o'clock, I'll come. Actually, at 2 o'clock, my lord, because the absence of AG on matter has been fixed in court number 27. Just across the corridor.
Okay, then
We'll come little late, my lord.
after some time we'll take up.
Deep love.
How many hearing meters? We'll take up 10 minutes.
Thirty-six of daily hearing. Thirty-six.
None appears for the pitch. MS Pilas, Standing Council represents the
Secondary education.
secondary education. Please, Dr. Puja.
Deeply obliged.
37.
So, my lord, I am for the petitioner.
Yeah, appearing?
Yes, ma'am. I'm for the college authority.
Your lordship. Lordship. My item is 36 actually. My item was 36, Your lordship.
Where were you?
I was outside with all people, just now I entered the room.
Don't you keep on talking on the phone outside?
No, Your lordship.
Why have
all of
you
a sudden, I'm waiting for this matter for so long. Your lordship, kindly, Your lordship. After this matter, Your lordship.
I've already passed order. Yes.
May it please you, my lord.
1 minute. Your college.
I'm for the college.
That is 3, 4, 5.
My lord, 3 and 4.
3 and 4. Higher education.
For 5 senior council.
I'm for 5, my lord.
Okay, you're 4, 5.
Affidavit also.
I begin, my lord.
You all ready?
My lord, affidavit already, so everybody file, my lord. I have also filed affidavit, my lord. Yes, yes.
The petitioner has got engagement in other colleges. He wanted to know whether she is also employed, a permanent government job. Whether does she want to continue that instruction was supposed to be placed before your lordship?
I would like to take my lordship to
What
the
on that?
initial order. The initial order is as such that the appointment of the respondent number 5, Srimati Maitri Dotto, as assistant professor in English in Kagurijan College, Nagaon, shall be subject to the final outcome of the writ petition. State that
So you have been appointed as in Tezpur College, isn't it?
My
As a
lord.
professor in English.
She has been appointed after 2 years. She has spent 2 years quite without the job. Here the entire issue is not the appointment of the petitioner. Issue is the illegality of the appointment as such in the Kagurijan College of respondent number 5. And second issue is the whole appointment procedure in the Kagurijan College, while the respondent 5 was selected, it was an opaque procedure, the vitiated fraud and injustice has been committed. An injustice that has been committed in Kagurijan College is an injustice everywhere in the state, everywhere in the whole world. We have challenged the appointment of the petitioner and also the selection process of the appointment, selection process of the petitioner respondent 5 in the Kagurijan College. That is the issue.
So now the issue is this.
Yes, my lord.
As per your prayer, you want the appointment of respondent numbers 5 to be set aside?
Yes.
He should be appointed.
And you should be appointed.
But that is, my lord,
One
that is not
minute,
mandatory.
1 minute.
Our main issue is, my
1
lord.
minute.
Yes.
You should be appointed, correct?
Yes, my lord.
Supposing you are successful,
Yes.
are you willing to give up the job in Tezpur College?
Yes, my lord. That will,
Do you have that
that will be after. But legal issue here is that main issue in this petition, is the appointment of the respondent 5, Ms. Moche Dotto, is vitiated by fraud, vitiated by wrong process of selection, and also that is the issue.
Fine.
That
Have you gone through the order of 14/5/2024?
That order I have gone on. That order states that
And on that basis, have you received the instructions?
we have been verbally told that she is willing to pursue this writ petition to its logical end, my lord. That is the issue raised here. She is willing, she is bent upon pursuing this writ petition to its logical end, whatever the outcome may be. That is the issue, my lord.
Okay.
My lord, another point, my lord, before argument, my lord, your lordship kindly see, I got first and that petitioner got third, my lord. But second was not made a party. Even is, my lord, your lordship, my lord, set aside and she will not get, my lord. Person who is in second, my lord, he is not in party. Not a permit party before this honorable court, my lord.
Who is the select list?
My lord, select list, your lordship will find.
It is in my affidavit.
Page, my lord, no, your lordship statement goes to my lord petition. Annex 1. In its petition, probably.
Is it page 20?
Yes, my lord, page 51, your lordship kindly see, page 51.
51?
Page 51 of the, my lord. Sorry, my lord, read petition, my lord.
We have in fact challenged, my lord, the opaqueness of this selection process. That is the issue, my lord. Main issue is that. And the application, not in terms of the advertisement, has been accepted, which is erroneous, totally erroneous. That is our submission. Because
page 35. Page 35. Page 35 of the petition, my lord.
बाकी वाला पेज पे ले रखो हम
Page 35, my lord.
Annex 1.
Annex 1.
Page 9, internal page 9.
Yeah, internal page 9, my lord. Yes, has your lordship got page serial number 4, my lord?
Yes.
Serial number 4, Bhumika Devi. She got second. And serial number 12, Moiti Dotto got first, my lord. And serial number 14, who is the petitioner here? She, my lord. She is, my lord, third. So second is not made party, my lord. So, my lord, in the college authorities, my lord, affidavit, my lord, that signature is there, my lord.
Hmm?
It is very clear in, my lord, respond number 3 and 4, my lord. It will be clear from this, my lord. That is the college authorities, my lord, affidavit.
It is on record, madam. The affidavit filed by the college.
Respondent?
Respondent 3 and 4. We have annexed the comparative status.
Provisional, that's not. Provisional.
Annexed are 2 of that affidavit.
Did not appear. Did not appear in the interview. Are you sure about it?
It's the same one. Serial number 4, isn't that?
Serial number
4 is second.
is second.
62.96.
No, no.
Not six.
12.
12 is the respondent number 5. They got 63.47. And the petitioner might not have serial number 14. He got 62.63. First objection is that even if assuming for a moment, without going into other aspects, if your lordship allows this petition, the petitioner will not is not the person who will get the document. The person who is above the petitioner has not been implemented. And even after that point has been taken up in the affidavit, thereafter also they have chosen not to implicate that person by amending the petition. Other aspect, I will submit, my lord.
I'm ready, my lord. I can submit, my lord.
What do you say on this?
My lord. The lordship may kindly refer to initially page 20. Page 20, the Moitri doctor, she has secured marks 61.47. And the Mandana Sharma, she has secured marks 62.63. The claim of a superior candidate has been passed over in favor of an inferior candidate in the appointment of a college professor in Kagurijan College, which has vitiated the entire process of it. That is our
What is
mention.
this page 20?
Lordship, this is the day whoever applied. On
No,
the
that's it,
basis of
yes,
that, this is not a
Their
statement.
assessment.
No, let me finish, my lord.
No, I'm just checking. Huh?
This is not the statement of the selection committee. To bring fairness in the process, whoever applied, that was uploaded. Only signature of the principal is there. There is not the minutes of the selection committee or any comparative statement of marks. Here, lordship will say there are 20 candidates, many of them were not even participated in the when the actual interview took place, my lord. So this will not give, confer any vested and concluded right, my lord, this document.
What do you say on this page 52?
Page 52.
Affidavit of respondents 3 and 4, is it?
Yes, my lord.
Affidavit of respondent annexure 2.
Affidavit of respondent to an, my lord, as regards selection of respondent number 2,
The affidavit filed by respondents 3 and 4.
those affidavits are vitiated, my lord, altogether. They are not based on truth. Most of them are wrong because, let me explain, my lord.
Okay, then we'll continue. At
Initially, my lord, we have to go through the advertisement.
Continue at 2. We'll continue at 2 o'clock.
All right.
Yes, sir. Because he's disputing this page 22, page 20.
Earlier, my lord, the record was called for in this matter. I thought that.
See, one issue is here. They have raised one objection that you come under the serial number 3. Your position is serial number 3. Serial number 1 is the private respondent. And there's another person between you and the private respondent. Now, that person has not been made a party. Now, supposing if you're successful and the private respondent's name goes, still then the other person who's above you, then
Here the main issue.
no relief can be
No,
granted to you.
main issue, my lord, if I can submit. So, the primary issue here is the selection process is totally flawed, initiated. And the application, no, that is the main issue.
That is the issue. That is the if the selection process is
And my lord, the second one, the second appointee, also is she has not challenged, and that point has not been raised at all in the initial affidavit in opposition too. So that point is irrelevant here altogether. Issue is twofold, very simply. One is an application that has been.
One thing, it has been brought to your knowledge that there's another person above you.
Yes, ma'am.
And that person has to be impleted. Despite having the knowledge that one person is above you and you don't choose to implete him, there's already a judgment, Supreme Court. On that ground alone.
If your lordship directs us to amend the petition, then we shall amend accordingly.
I'm not question of any liberty, my lord. At the hearing stage, my lord, there is no question of liberty.
Anyway, since Das wants to produce the records, let him produce the record. But Mr.
Judge Chaudhary, my lord.
Chaudhary and the council. Also,
then we shall impede it, my lord.
My lord, that is absolutely, my lord, at the hearing stage, my lord, impeachment.
Also heard, you're for this school.
I'm for 3 and 4, my lord.
Mr. T. Jagapati, led the counsel for the respondents 3 and 4, and Mr. T. J. Mahanda, led the senior counsel, assisted by Ms. Ivata Jarchi for the respond number 5. On request made by B. Das, S. Das, Leonard Standing Council Higher Education. It leaves the matter of the puja application to enable him to produce the records.
With your lordship kind permission, if you can say so. The main issue here is the appointment as such is totally erroneous, and the selection process is totally wrong. That is the two issues that are challenged. But whether the second person or third person, whoever we are, we have challenged the main fundamentals and material issues in respect of this appointment. Whether we have a right to appoint.
PIL, my lord, and quickly apply.
For a petitioner here, my lord, prayed for my lord, release of family pension. She, her husband worked, my lord, as a teacher, my lord. Head Pandit of Vivekananda LP School, my lord, Bokazan, Karbi Anglong. There, my lord, what is from 69 to my lord, 92, worked there, my lord. So 23 years there, and my lord, I have filed one additional affidavit also, my lord, wherein it is evident that record shows that all the records have been already, my lord, somebody has stolen and damaged it. Anyway, my lord, otherwise, my lord, they have already processed, my lord. And authority, I have seen petitioner inform me that process has been already officially completed, my lord, to release the same. But one simple order is necessary, my lord, from this honorable court to my lord, dispose of the matter in accordance with law.
Have you processed the matter, P.N. Sharma?
Lord, I think the matter pertains to my lord.
They have filed their affidavit, Lord. Lordship has filed their affidavit, Lord.
District Elementary Education Officer. DO.
DO, Lordship.
Respondent 5.
Respondent 5, Lordship.
Who is the statement that?
Here, Lordship. Relevant paragraph 8 and 9, Lordship.
But then the Das is saying that petitioner's case has been processed.
Yes, my lord, already processing the.
Paragraph 9, Lordship.
Hmm.
The petitioner was appointed by the Secretary so Caribbean Autonomous Council, Defu, by an order dated 24/1/1969. The
69.
husband of the petitioner, Sachin Kumar Das, died in 12/7/1992 while he was serving as head pandit. As the husband of the petitioner died before the provincialization of service of the teachers of the Vivekananda, the pension paper, paper of the petitioner could not be processed for the end of from the end of the department. It is clearly written here.
But then you are saying it has been processed.
Yes, my lord, because my lord, there is judgment also, I have annexed here, my lord. Yes,
No.
He is
Yes,
only
my
right.
Come to the factual.
Yes, my lord.
Has your case been processed by the
Yes,
respondent?
client informed me, my lord, informed me, client, but
But on record, they have.
On the affidavit, they said they cannot process.
yes.
You are appealing for the case. Have you processed the petitioner's case?
No, Lordship. As per our affidavit, paragraph 9, Lordship, we have stated here, Lordship.
Oh, that I've gone through. Then why not you take instructions? Whether they have processed?
Yes, my lord. Documents, if it is there, my lord, I'll
You
bring, my
can
lord.
see down on the basis of that, we can dispose.
Yes,
of
my
it.
lord, yes. my-
Okay, on request made by Das, land council for the petition. List of the.
43 of supplementary list. Admission.
May I please your lordship?
Affidavit has come?
Yes. Yes, ma'am.
Yes.
My lord, as the matter was regarding NEET examination, my lord, and it was regarding giving lesser mark than I actually obtained. And it was a case of earlier one was 21 and 23 and then 24, my lord. My learned friend has filed an affidavit in opposition in this regard. My plea is that, my lord, as per the answer key I have received downloaded from the NTA in my mobile, I have obtained the 656 marks, my lord. The answer OMR sheet is not in dispute now, my lord. So far as the OMR sheet, my learned friend has annexed a copy of it with the affidavit. It is not in our dispute. Your lordship has called for the original, and it is with the record, perhaps. Now my learned friend has disputed the answer key. According to him, I have manipulated it. Last year, my lord, in 21 case, I have annexed the order. In 2021's case, my lord. Similarly, they disputed my OMR sheet. Thereafter, the OMR sheet was called for by the Honorable Court, original OMR sheet. After calling the Honorable Court recorded its findings that the OMR sheet I have filed and annexed downloaded from the who they have questioned. That time they questioned and the authenticity of my OMR sheet. But when the OMR sheet original was called for by this Honorable Court, and one answer was compared by the Honorable Court, answer number 5, my lord, or question number 5, compared that which one I have claimed is correct. And finding that, the Honorable Court directed to make an immediate inquiry, to submit report, and then to proceed file an affidavit. After coming to the affidavits thereafter, my lord, my learned friends, the other side has filed their purported so-called OMR sheet, my lord, which is not matching with the original. But original is taken back, returned back by the court, and making it a disputed question of fact, still pending, it is there, my lord. The Honorable Court has recorded its findings, my lord. Then what happened, my lord? The Honorable Court, my lord, also called the machine, the mobile on which I have downloaded in the court, and tested it by engaging two a mechanical expert of online system, my lord, computer system, mobile system of this Honorable Court, and then found it is correct. One week my mobile was kept with the court, my lord. Of course, it's not in recorded because it's part of trial type, my lord. That's not recorded, but it is done like this. Thereafter, they filed the affidavit disputing the fact that mine one is not correct, their one is correct. So making a disputed question of fact 2 to 6 is difficult to decide, my lord.
This year, my lord, they have questioning my answer key, my lord, that I have faked it. Now, my lord, OMR sheet question gone. What they have produced and what I have produced is same. Only answer key is now in dispute, my lord. Now, regarding the affidavit, my lord, kindly turn to page para number 6 of the affidavit in opposition, my lord. Para number 6, my lord, page 62, my lord. Para number 6, my lord. That present petition deserves to be dismissed at the outset on the ground that petitioner has sought to set up a false case against the answering respondents by placing reliance on forged and documents as Annexer B and C. Annexer B is the answer key, my lord, and Annexer C is the recorded response sheet, my lord. My learned friend has stated that I have, my lord, manipulated both, but my learned friend is quite incorrect, my lord, in the fact that, my lord, the Annexer C, which is the response sheet, my lord, is a recorded response sheet, is exactly equivalent to the OMR sheet, my lord. Just copy it in pages in broader manner and furnished it on the online, my lord. So I am also not in dispute, and learned friend is also not in dispute that OMR sheet is no dispute regarding OMR sheet already with me and with learned my friend, my lord. But here my learned friend is saying that I have failed the recorded response sheet also, which is even same matching with the original OMR sheet. There is no question now remains, my lord, at all. And my lord, this is quite incorrect, my lord, submission, my lord. Now, my lord, kindly turn to, my lord, para 7, my lord. And my lord, sorry, in the same paragraph, my lord, yes, my lord, 7 paragraph, my lord, that the petition is bad in law for its conviction. The allegation that the respondent has changed the final score card to 51 marks, but out of 720 is without any passage, and has not placed his OMR sheet answer sheets to substantiate his claim. This is also incorrect, my lord. I have not got it. That is why my 10/6/2024 representation is there, annexer, my lord. Then, my lord, they replied, my lord, they will revert to me for my redressal of my complaints on 18/6/2024, but they have not reverted. Thereafter, on the Supreme Court orders, when the NTA re-uploaded all the OMR sheets, my lord, then I have got my OMR sheet. On after filing the repetition, my lord, I have come to know that, and I have filed the IA, my lord, and with it I have Annexer 6, my lord. But my London friend is I'm suppressing, not placing it before this honorable court. It is also incorrect, my lord. My lord, then my lord, come to page para 23, my lord. Para 23, my lord, page 73. My lord, the term of chapter so and so displayed the scanned images of OMR answer sheet and recorded response of NET along with provisional answer key from 29.5 to 31.5. He's saying that, my lord, answer sheet was displayed and I have got it. And OMR sheet also, it is incorrect, my lord. OMR was not given at that time. OMR was given later. OMR sheet was only answer key was given. It is also incorrect, my lord. Now, my lord, come to the my lord, subpara of this para 23, below, my lord, below the annexer line, my lord. It is pertinent to mention herein that the petitioner did not raise any challenge with respect to OMR grading or answer keys during the challenge period. My lord, how can I challenge it, my lord? I have got the answer key. I have got the response sheet, answer response sheet, my lord. This is a broader copy of the OMR sheet sent by the NTA by extending it in more pages because OMR sheet is very small, cannot be read sometimes read, my lord, properly. So it is sent to all, my lord. I have got it. And according to my answer key, I am satisfied. Is matching. Answer key, my answer key and the response sheet they are given. Then why I am to challenge, my lord, at that point of time within 25 and 29, the notification, my lord? Because I was satisfied with my response sheet and my answer key. Okay, this both was matching. Now, my lord, this is also incorrect, my lord, so far as my understanding is concerned, my lord. Now, my lord, para 24, that upon perusal of the record maintained at NTA and the documents annexed by the petitioner, it has become apparent that Annexer B alleged as final answer keys of booklet Q number Q1 and answer Annexer C is doctored. Again, my lord, what is Annexer C? Kindly see my repetition, my lord. Annexer C is, my lord, Annexer C, the response sheet, page 20 to 50, my lord. 20 to 50, my lord, of the repetition, my lord. Annexer C, copy of the response sheet, or answer sheet, my lord, that is page 20, from page 20 to 50, my lord. That is a copied from the OMR sheet sent to all the students for their comparison, understanding, if required, to challenge. But my answer key and this response sheet is matching quite. That's why I need not, my lord, to file any challenge. My learned friend has, the other side has mentioned that C is doctored. My C is not, I'm disputing at all now even. My learned friend also agreed. Through my it is matching, my lord. C is the response sheet, which is also matching the OMR sheet. Exactly, my lord. Exactly matching, my lord. So, my lord, it is also incorrect, my lord, submission, because it is not in dispute at all, my lord. My lord, kindly turn to page 38, my lord. This remaining part is my rules and regulations, sir, my lord, in between, my lord, mentioned, my lord. Page 38, page 79, my lord. Page 79, my lord, of the affidavit in opposition, and para number 38, my lord. In the bottom, my lord, last para. Affidavit in opposition, page 79, my lord. My lord, kindly see the para 38 bottom, my lord, in the bottom. It is also brought to notice that the final answer key dated 4/6/24 annexed by the petitioner seems to be forged and modified prima facie. They are not sure that I have forged it. There seems that, my lord. Impliedly, they are not denying, my lord, not rejecting. They are not sure that I am forging it. On last occasion, the mobile was called for. Candidate was called for. It was kept with the court for 1 month by Honorable Justice, my lord. And then, my lord, it is found that I was correct, my lord. And you kindly see.
Okay, let us come to your writ petition first.
Yes, my lord. Now, my lord.
Why are we going to the
First of all, my lord, page 17, my lord, annexure A of the repetition. My lord, this is the, my lord, entrance test. This is perhaps the admit card, perhaps, my lord. Application number so and so, roll number so and so. This is given, my lord. This is not in dispute, my lord. Then, my lord, this is the answer key at page 19, which I am claiming to be correct and given to me by I have got it from online.
This was put up by the.
This is my lord. This is my claim, my lord.
What is exactly we are saying that it's a.
Dispute is here in this page, my lord.
This answer key is incorrect, my lord. Where from they have got it is for the petitioner to explain. Even as on date, my lord, the correct answer keys are still there in the website. My lord, in fact, what has happened, my lord, it is subsequent to the order passed by the Honorable Supreme Court, revised answer keys were published, or that we have annexed. My lord, the entire edifice of the case, my lord, will, depends on this answer key. Now, in their own thinking, my lord, petitioner is saying that this is the answer key, so my answers are right. In fact, this is completely a false document. Where from now, if it has to be proved here, my lord.
Where have you taken down this answers?
My lord, from the NTA website, my lord. What my London friend is saying, my lord, regarding Supreme Court and direction for republishing the answer key, my lord. My lord, in my case, it is incorrect, my lord. It is correct, it is republished, but what happened? My lord? Only one item, only one question, question number 19 perhaps. 19. Only one question or answer is changed, which I have not attempted. So it has not connection with me. I have not attempted that question, my lord. I left it, my lord. So this has no connection with me at all.
Even still, that is wrong. Even that is, my lord, there where I will just. Lord, there were two answer keys, my lord. Last occasion also I have produced it. Initially, my lord, one answer key is dated 5/5/2024.
Where is the date?
On the top.
Okay, yes,
5/5/24. And thereafter, my lord, on 26/7/24, pursuant to the directions of the Supreme Court, my lord, revised answer key was published.
Where is that?
There's the next page. The next page. And these both the answer keys are same except question
Only
number 19.
Point number 19.
As my learned friend is saying.
Yes, sir. I have not attempted
Now,
it.
if we compare these two answer keys with the answer keys given by the petitioner, completely mismatching, my lord. So where from this has come? That's really shocking, my lord. These
Except question number
19.
19.
19, nothing was
19, it is 1,3.
3, 1
In
or
the
3.
first
In-
answer key.
Yes, in the yes.
After the revised, 19 is now 3.
Yes.
Yes.
That is the change.
Yes, that is the only change.
Which I have not attempted, my lord.
And so far as
Okay, that's fine. And then
and these two documents, and while Leonard Penny is also not disputing now, if the question is only the answer key, it is still on the website. These all are, my lord, matters of evidence now. He is disputing the internet things, my lord. Where from he is downloaded?
from where did you download this?
My lord, from the NTU website, my lord. My lord, your lordship, kindly turn to page, my lord. One thing your lordship will make it clear, my lord. Page 57 of my petition, my lord.
When Leonard Penny has just now admitted, my lord, the revised answer key is correct.
No, I'm not saying
Except
that.
19.
No, my lord,
Question
no.
number
I'm not
19,
admitting.
Leonard
I'm
Penny
saying that
says
revised key, my lord,
that the
only
revised
19 is
is having the knowledge of the revised answer key. But the my lord, the answer key which is annexed here, it is completely mismatching. And he's relying on this heavily.
It is published after the Supreme Court judgment or some orders, my lord. I have come to know. As only 19 is changed, I have no connection with it, my lord. So I have not gone through, not checked, because only 19, I have not attempted it. I dropped it.
See, what you are saying
Yes,
is that after the Supreme Court order,
yes, ma'am.
the revised answer key was published,
My lord.
was uploaded.
Yes.
There, the issue is that question number 19 was changed.
Yes.
The answer to the question 19 was changed
Yes.
from 1.3 to 3.
Yes, ma'am.
But then if we see these two documents,
Yes, ma'am.
which was first uploaded 5/5/2024 and thereafter revised on 26/7/24. Now all the answers are same except answer question number 19.
My lord.
But then are you saying this revised answer key is correct?
I'm not saying because my lord, what I have got, kindly turn to page 19, my lord. It is, my lord. I have also downloaded from 15524, my lord.
That I've seen.
My lord. Now, my lord, one thing you make it clear, my lord. Kindly turn to page 57, my lord. I'll lead you less to a paragraph only, my lord. Page 57 of my petition, my lord. Page 57, my lord.
Yes. This is with regard to some other case.
Yes, my lord. Exhibit what they have done, my lord. They are saying today they are not.
We are not going back to that case. Let us concentrate on your
how
case.
they have changed the, my lord, the OMR sheet even, my lord. After submitting before the court, it is changed, my lord.
No, this court is not going to be influenced by for the pendency of one petition.
My lord,
that case will not influence this court. This case.
My lord, correct, my lord. But only I want to only to say that, my lord, that once an OMR sheet being produced before this honorable court, the court checked and compared and found me correct and they are wrong. They are manipulated. Then the court returned it, ordered for an immediate inquiry and to finally submit a report. When they submitted the report with additional affidavit, they changed submit the forged one, removing the original one, making it a question of dispute, my lord.
Come to page 19.
Yes, fine.
See the one that they have just submitted now on top. National Testing Agency. There's no spacing at all.
Yes, that's correct, my lord. That I have seen, my lord.
And the final answer key for net so and so here
Yes,
also there's
yes,
absolutely
yes.
no spacing.
Yes, I have seen, my lord.
In the one which they are producing,
My lord.
there's a space.
My lord.
There's spacing.
Yes, my lord.
So how do we know? This becomes a disputed question of fact.
My lord, this time also, earlier also, that makes it dispute question when this 2 to 6 is becomes, my lord. And I am getting frustrated and deprived again and again. Last time court found it, I am correct. They are wrong.
From what system he has downloaded, then an inquiry has to be made. Then there has to be a detailed inquiry, my lord. Then we'll have to check it, what computer system from there, where he has downloaded. If he is stating and stressing on it, my lord, that it is correct, then, my lord, there has to be an inquiry. As on date, my lord, prima facie, these two documents, my lord, and the answer keys, my lord, they are completely mismatching. How can it be, my lord? It's a national level examination. My lord, no authorities will take it, my lord, like this, my lord, conduct the examination in this manner. My lord will match the questions, page 19, and my lord, The document which I have given 5524, all the answer keys, the answers are different.
From where did you, how did you download this?
My lord, as per the boy has told me, my lord, it is downloaded from his mobile. He has sent me, he has shown me this PDF file, my lord, and he also sent it to me also PDF file, my mobile. That's I have known. Last time also similarly happened. It was verified and found correct. I am
For
correct.
one candidate, my lord, it cannot happen.
I
my
don't
lord.
know, my lord.
All
Exactly,
over India,
it
my lord,
seems to be
lakhs
like
of
this, my lord.
students apply.
What I am saying, it seems to be logical, my lord. But till what happened to me last time, the code itself found it like, my lord.
Now,
I am
that is
correct.
I refute, my lord. The earlier submission, my lord, which my friend is trying to relate, it's completely wrong facts is related. In fact, my lord, there was an inquiry that it petition is not before your lordship. The submission which my learned friend is making that it was found to be false is not correct. But
My
I
lord,
am
recorded.
sorry to say, my lord,
Paragraph is
again a wrong statement. In that case, my
kindly
lord, we'll
go to
have
the paragraph, my lord.
tag that petition, my lord, for hearing.
Kindly go to the paragraph 11
That's
paragraph.
a wrong statement, my lord.
It is court's findings, my lord, not mine. My lord.
No, there is no such finding, my lord, saying that the Omar sheet by the that was fraudulent, my lord.
No,
There is no
this
such
word is
finding.
not used exactly. This word is not correct.
Then,
This
my
word is
lord,
not
how
used.
can I,
But my the
word can
honorable
be
court has mentioned that this mine one is matching, my lord.
no, there is no such finding.
Compared one answer with question number 5, my lord.
Yes.
My lord, this is my submission. The remaining is up to your lordship, my lord. What to do?
Yes.
My lord. No, the main case is, my lord, on the answer keys only.
Only on this
Only
election
on
date.
this issue, my lord. And entire, it's all whimsical, my lord.
So it is not telling at all.
Not telling at all with our answer keys, my lord. Now, how can whatever the petitioner says can be accepted, my lord, as an authority for one student, my lord, where from he has got this answer key, he is not able to tell it. Just, my lord, telling that from the system it has come, my lord. In that case, there has
My
to
lord,
be an inquiry.
many
detailed
students are
inquiry.
there, my lord.
How
Many
he has downloaded, what is the website link, my lord, those things have to be checked. And you know, as an authority, it's not only for one student, but there are lakhs of students appearing. And it is still there on the website. And 2 documents which I have given, my lord, it is on website since, my lord.
My
the
lord, many
declaration of
things
the
happen. It
result.
is seen in the Supreme Court cases, my lord. Many things happen. Anomalies are found, my lord.
So he cannot relate everything
That,
to his case, my lord. And my lord will take, my lord,
yes.
paragraph, my lord, 21, 22, and 23 of the, my lord, affidavit in opposition file. My lord, in case of a, my lord, dispute regarding the answer key, no, there is a provision under the advertisement
my lord, we have stated in paragraph 21.
To the challenge, to be,
To the
make-
answer keys. Yes, my lord. There is a clause, my lord, in the information bulletin which says that, my lord,
No, according to him,
my lord,
when he downloaded that answer sheet,
my lord.
Answer key, my lord.
answer key, it was according to his, so there was no necessity to change. But then today you are producing something else.
No,
which
my lord,
is
it is
which-
already there.
No.
Yes, in the
Today
affidavit.
we are producing one answer sheet,
My lord,
one answer key,
my lord.
which is not at all telling with the which the petitioner claiming is the
Yes,
correct one.
my lord.
So I think this time also we'll have to call for an inquiry.
No, it is already there in the website. No, this is all a presumption, my lord. And it's all assumptions made by the petitioner, my lord.
From where did you download this answer key?
According to the boy, my lord, he has downloaded from the NTA website, my lord. He's shown it to me as a PDF from his mobile. I checked his mobile, but I cannot check whether it is rightly connected. They have no idea, my lord. He has but shown me. They downloaded on that day.
My lord, will see paragraph
PDF file.
Statement made in writ petition, my lord, paragraph 6. What he has stated, my lord. He is saying he has downloaded, my lord. What the statement made in the writ petition is different. My lord, if I may read, my lord, that the petitioner begs to state that he appeared in the NEET examination 2024 held on 5/5/24 and performed far better than all previous years. After the test examination, answer keys of the NEET undergraduate 2024 examination held on 5/5/24 was provided by the NTA to the petitioner. It's a vague statement, not provided. NTA cannot provide, does not provide answer keys individually at home to the
Not
candidates.
individually, never individually.
Okay.
All
It is
online.
downloaded in the website.
All well, no, I mean, never saying that will
the
personally given to me. All
What is this statement?
Downloaded, my lord, and then further he states, my lord, provided by the NTA to the petitioner like other similar candidates.
Exactly, my lord. That's what I wanted
And
to say.
as per the
All
answer
of-
keys.
everything is online, nothing physical.
He found, he again checked. So, my lord, he is saying that it is provided by the NTA. What is the meaning of
My
this?
lord, if I download it from the NTA and the NTA is saying go get it download from the NTA, this is that. Is it not provided by the NTA, my lord? Not hard form, but in soft form.
At least he could have, my lord, put that link, my lord. He said, he has stated that, my lord, it was downloaded from a link. That particular link is also not stated.
Why not you get instructions from your client from which link he downloaded this?
Just let him, my lord, file an affidavit to that effect, clarifying.
After that, we'll pass appropriate
Yes.
orders.
And where from he has downloaded? my lord?
Mr. A.K. Talukdar, learned counsel for the petitioner shall take instructions and after file an affidavit indicating from which link the petitioner had downloaded the final answer key for NEET within bracket UG-2024 examination
Q1 series, man.
held on 5/5/2024.
5/5.
Annexure B, my lord.
Which is annexed to the writ petition as
Yes.
Annexure B. Stop. When can you file it?
But vacation.
My lord, in any view of the matter, the subsequent answer key, my lord, he is not disputing that. But 26/7.
There is puja vacation, my lord. Can it be after puja vacation?
My lord, because one interim order is there.
Yeah, I know.
So it has to be before the application because.
Yeah,
Because, my lord, last date of admission at any rate, my lord, the admission cannot go beyond 30 October, my lord.
That's why we'll get it disposed of before 30 October.
Yes.
We'll have it immediately after the reopening of the puja.
Yeah.
Then we'll take steps.
Because, my lord, there is a process, counseling and seat allocation. So in one day it cannot be done, my lord. That has to be considered, my
That
lord.
is that way. We'll list it on. This is one case I'm fixing a date.
Yes.
List on. When do you want?
My lord, immediately on the.
On the opening day you want it?
Yes.
Can you file it?
Hello.
On 21st,
My lord, maybe on next day because I have to file it and to come on record.
on 22nd.
22nd.
After you produce, after you provide the link,
Yes.
only then I think we can come to a
My
conclusion.
lord, interim maybe continue.
Okay, interim order procedure to continue till the
Right.
next week.
44 of supplementary list hearing.
Yes, my lord, we have actually came against the order of rejection of our appeal, my lord. It's in a nutshell is this, my lord. Our college was established in 1999, my lord.
Who appears for the union?
My lord.
NCTE. Because they are the actual authority, money. It's a formal just government union of India.
2, 3, and 4.
2, 3, and 4.
Because the recognition, everything, cancel, rejection, everything is done by them only, 2, 3, and 4.
And what is respondent 5? That has been deleted.
That is deleted, my lord. That has been deleted.
And the union 1, at least but somebody should represent the union.
I hope to also union of India.
Affidavits filed?
Affidavit filed. Affidavit filed.
It is complete, my lord. It is complete.
When did you file your affidavit? Okay. It's on record. It's on.
Okay.
You filed your reply? No.
Reply, yes, no. We file our reply.
You filed your reply?
Yes, yes, Lord. Replied for.
Okay, yes. Replies.
Yes, yes. May proceed, Lord.
Okay. Union's presence is not required.
Not required.
Okay. What is your case?
Yes, ma'am.
2016.
My lord, then in 2000, actually, my lord, it comes, Joe School College are established in 1992, 2016, my lord, we applied for a recognition. My
When
lord,
was your college established?
1999, my lord. The Aram, the two of them, 1999. My lord, 2016, lordship. 2016, yes. Established, my lord.
Huh?
2016, my lord.
Yes.
Then, my lord, on 9/4/2018, my lord. 9/4/2016, my lord. The university, Guwahati University granted us an NOC for opening of the B.Ed course, my lord. On 23/6/2016, my lord. It was on, lordship will find it at 38, my lord, page. Page 38, lordship. It is of 29/6/2016. As the affiliating body of the University of CRT has no objection to affiliate the appellant institution Mehtab Jamal B.Ed College, which is so and so, so and so. So they applied for B.Ed program for recognition by committee of NCRT, because my lord, that is required before my lord making an application to the NCRT for granting recognition. So the Guwahati University has granted us the recognition, my lord. So inspection, everything was done. Now, my lord, no objection certificate was given by SCRT also, my lord. Page 40, lordship will find next page.
Page
40, lordship.
No objection was given by
Both
the
first
Guwahati
Guwahati University and my lord thereafter by my lord the NCRT. This is required, my lord, for making SCRT, my lord.
State Council for
State NC Council for Education and Research Training.
2016.
Lordship.
By Guwahati University.
Yes, my lord.
And by the
It's on 15/6/2006, 15 November 2016, my lord, page 40. Then, my lord, after getting all this, we made an application, online application, that my lord will find it on 30th June 2016, my lord. Lordship will find it, page 44, my lord. Start from online application, page start with 43.
What is this online application?
But that is that application which is required to be filed, my lord, for application for granting recognition by the NCTE. So I have to file online, my lord. So this is that we have filed it on 30/6/2016, my lord. So online, my lord will find it as 44. Page 44, my lord. Page 44, lordship will find. That is date of application. Now, my lord, a decision was taken on, my lord, 20, my lord, on 27/8/2019, my lord. That, my lord, will find it page 48, my lord. That is how the things began. That is the starting point of, my lord, the litigation, actually. Page 48, my lord. Because it is placed before the ERC, my lord, because it make Eastern Regional Council, which is in Bhubaneswar, then, my lord. So applied there, now lordship will find permission for opening of the B.Ed college, so and so. My lord has got it, page 48, my lord. Then will lordship will resolve that the college be granted permission with the following condition: a library, equipped with books, journals. What invested?
Page 48 is in respect of a degree college.
Degree college, my lord. And now, my lord, will page 49, lordship, Annex 12.
What date is this?
Yeah? My lord, that, my lord, my lord, decision 28 and 29 January 2017, proceeding of 231 meeting of the ERC NCTE. Lordship will got it on the top of it. My lord, top of it, lordship will get it, page 49, my lord.
No. Page 48. This is for degree only. Eh?
This is for degree only, my lord.
What date is this?
This is, my lord, 10/5/2019. On the top of it, lordship will got it. Lordship will get it. ECA, so and so, Mehtab Jamal B.Ed College on 10/5/2019 resolved that the college be granted permission opening a new degree college art with the following condition. Then, my lord, will find the, my lord, the annex, my lord, continuation at page 49, lordship. Page 49, my lord. The decision vis-a-vis this petitioner's college, my lord, will find that, my lord, and lordship will find it is a proceeding of 231 meeting of ERC NCTE held on 28/29 January 2017. Lordship has got it on top of it, my lord. Page 49. Then lordship will find below that Mehtab Jamal B.Ed College, so and so. After considering, my lord, will if your lordship down below, after considering examining the application along with the documents submitted by the institution, the agenda note NCTE, etc., NCTE regulation 2014, including the norms, standard of the guidelines received from the NCTE headquarters from time to time. Now, lordship will find, as per online application, institution apply for additional intake in B.Ed program, but the institution has no prior recognition for ERC NCTE for B.Ed program. The statement is not correct, as the institution applied for a single B.Ed course which come under stand category are not permissible under the NCTE regulation 2014. My lord, these are the ground, my lord. These are the ground that, my lord, the institution submit a list deed from a private party which is not accepted. Non-encompassment certificate issued by the land registering authority is not submitted. Building plan is not approved by the government engineer. Then, my lord, building completion certificate issued from the government engineer authority is not submitted. Change of land use certificate issued from the land divine authority not submitted. Fire safety certificate, site plan, this and that. Now, after considering all this, now my lord will find that in view of above, the committee declared under show cause notice be issued. So, my lord, they have scrutinized our application. We have submitted through online. After scrutinization, they issued a show cause notice, my lord. Show cause notice be issued to the institution as to why the application applied for the recognition be not refused on the above points. The committee therefore provides last opportunity under section so and so of the NCTE Act 1993 to the institution to submit its reply within 21 days from the date of issue of this notice before the committee takes a final decision. So, then, my lord, it is appears that we thereafter, my lord, file all these documents, my lord. If your lordship look into, my lord, thereafter start from page 50. Lordship will find that page 50, all building plan, everything was submitted, my lord. So it's from 50 onwards, my lord. Yes, 52, my lord. It's from page 50 to page 68. Huh? Everything, they were submitted, my lord, through courier. And personally submitted, my lord. We only visited the place, their institution, my lord. We submitted all these documents personally, my lord. That what shortcomings were there, they noticed, my lord. It starts from page 50, my lord. And, my lord, now lordship will find the order of rejection, my lord. At page 15, my lord, what they say? Page, my lord, 69, my lord, annexer 15, sorry, my lord. It is of 2/1/2018, lordship. May I read, my lord? Whereas in terms of section 14(1) of the yes, my lord. Where in the terms of so and so, so and so, so and so, then, my lord, our case law apply for that, my lord will find BB Road recognition. Then, my lord has applied for grant of recognition to Mehtab Jamal B.Ed College, village so and so, my lord, lordship B.Ed program online on 36/2016 for 2-year duration. A hard copy received by the Eastern Regional Committee NCTE on 9/5/2017. Whereas the ERC in its meeting dated 2031, which I've already, my lord, showed to your lordship, that they by this meeting they noticed a shortcoming and accordingly they decided to issue the show cause notice. My lord, so that my lord will find it page, my lord. My lord, that page, my lord, 12. Sorry, my lord, page 49. If your lordship again to page 31, page 49, my lord, that is the minutes of the meeting, 231 meeting of the NCRT, my lord, ERC. So that now that has been also, my lord, taken note of in this order of 2/1/2018, lordship.
Yes.
Then, my lord will find para 2, and whereas the ERC on 23rd to 31st meeting was held on 28/29 January 2017, considering the hard copy of application and original file of the institution and decided a show cause notice was issued to the institution on 14/2017 through online mode. And whereas the institution has submitted any reply which was considered by ERC in its 247 meeting held on 16/17 December 2017, after consideration and examination along with the documents submitted by the institution, the agenda note, the NCTE Act, the NCTE Regulation 2014, including the norms and standard guidelines received from the NCTE headquarters from time to time, and no reply in response to SCN issued before BT The committee discussed the matter in detail and observed as under. Now, my lord, A, it is under 3A. Show cause notice was issued on 14/2/2017 on following grounds. These are the grounds, my lord. As per online institution has applied for and so and so. These are the recapitulation of my lord, whatever in that 2/3.
So you did not reply to the show cause?
No, that is their stand, my lord. We did not reply to the show cause notice.
According to you, you have replied.
Can my lord, but our stand is that, my lord, though they have sent it, we did not receive it, my lord. That will take a specific stand in our petition, my lord. Now, lordship will kindly see, in view of above, next page, page minus 70, my lord. In view of above, the committee decided as under. The committee of the opinion that application bearing code number so and so institution regarding recognition of applied BEd program is refused under section so and so of the Act, my lord. So our application for recognition was refused, my lord. Then, my lord, we filed an appeal online. That lordship will find at page 71, my lord.
So it is impugned?
Yes, against that impugned. Against that impugned order of 2/1/2018. That, my lord, will find it page 71. Appeal to, my lord, their appellate authority, appellate forum provided under the NCTE Act. Then my lord, lordship escape over. And
when did you file your appeal?
My lord, that was filed on 8/3/21, my lord. 8/3/20, and my lord will find it page 71. My appeal date. Appeal registration detail, lordship will find appeal date 8/3/21. Then my lord can skip only, and then my lord will come to the, my lord, the appellate order, my lord. Straight away, my lord, page 81, my lord.
Page
81, lordship. That is the appellate order, my lord. Lordship can skip over other, my lord, details. It starts from page 81, my lord, and XR 80. Lordship is got, my lord. Now, order, my lord. The lordship will find ground of withdrawal.
Yes.
My lord, the ground of withdrawal, the appeal of so and so college, Bonabhar 184 so and so, dated 8/3/21, filed under section 18 of NCTE Act, is against the order dated so and so of the Eastern Regional Council refusing recognition for conducting BEd course on the ground that show cause notice was issued on 14/2/2017 on the following grounds. As per on, so the ground was stated, my lord, on what ground there was refused it, my lord. And my lord, accordingly, and the ground of rejection. Now, my lord will see submission made by the appellant, my lord. My lord, the representative of Mehtab so and so college presented online the case of the appellant institution on 17/8/2021. In the appeal and during the personal presentation, it was submitted that due to shortage of time. Now, my lord, due to shortage of time.
What is this?
That I also do not know. That is their, my lord, findings due to shortage of time. Now, the, my lord, outcome of appeal of whatever that is it may whatever. Appeal committee, 8 page 83, my lord. Appeal committee perused the relevant records and the documents submitted by the appellant institution, decided as under. Committee noted that the submission of the appeal has been delayed by 3 years and 7 days beyond the prescribed period of 60 days. So, my lord, statutory period for filing the appeal as provided under the NCTE Act, my lord, it was 60 days. And so it was filed beyond, my lord, the 60 days, my lord. Now, lordship will come to para 2. Appeal committee noted that according to the provision of section so and so, any person agree with the order under section 14 or section 15 or section 17 of the Act may prefer an appeal to the council within such period as may be prescribed. According to the provision of section rule so and so, any person aggrieved by an order made under above mentioned section of the Act may prefer an appeal to the Council within 60 days from the date of issue of such order. According to the provision of section 18(2) of the Act, no appeal shall be admitted if it is prepared after 60 days of the period prescribed therefore, provided such an appeal may be admitted after expiry of the prescribed period therefore, if the appellant satisfied the Council that he had sufficient cause for not preferring the appeal within the prescribed period. The now lordship will see the appellant in the appeal has stated the reason for delayed appeal as delayed by Guwahati University for issuing permission affiliation for degree course. The committee noted the reason adduced by the appellant is not relevant as the show cause notice was issued on so and so date, which was not replied to at all by the appellant. So that is did not contain any point related to the university. The ERC refused permission on the ground of non-reply to show cause notice. So that is the ground, my lord, because in 231 meeting, my lord, just I have just taken your lordship, they say, my issue a show cause notice to my lord to reply before cancellation, and my lord, the final order of rejection by the ERC, my lord, NCTE said that we did not reply to the show cause notice, and therefore we rejected your application for recognition, my lord. Then an appeal was filed. Then in this appeal, my lord, committee therefore is satisfied that appeal is not that we are not prevented by sufficient reason to file the appeal within the statutory time limit, and solely on the ground of delay, my lord, not in any other ground. On the sole ground of delay, the appeal was rejected by lord. Now that lordship will find a decision. Para 4, my lord. Now therefore, after perusal page 83, my lord. Now therefore, after perusal of the memorandum of appeal, affidavit, documents, and record and oral argument advanced during the online presentation of the appeal, the appellate committee concluded not to accept the appeal on the ground of delay, and hence the appeal is admitted. Appeal is not admitted, my lord. So it is sole ground of delay that the appeal was filed beyond the prescribed period of limitation, and according to the appellate authority could not satisfy the reason why the appeal could not be filed within the statutory. It was delay. It was dismissed on ground of delay. Then, my lord, against that order, we preferred a writ petition, my lord, before this honorable court. It was WPC number 6612 of 2021, my lord. And before I taking my lord to the order passed in 6612 of 2021, my lord, I'll take your lordship to page 85, my lord. Because in this case, the NCRT appeared and filed their affidavit in opposition, my lord. That start from page 85, my lord, and X 19 lordship. Now, my lord, page 86. It is their affidavit, my lord. Page 85.
Anyway, just when was this petition disposed?
This petition was disposed, my lord, on 31/8/2022. 31/8/2022. That my lord will find it. Page, my lord, 90. Start from page 90. Now, before that, my lord, they filed an affidavit in that. Now, lordship will, if you start from page 85, my lord, now lordship will find page 86. Turn to page 86 of their affidavit, my lord. Para 2, my lord. Now, lordship will make that your humble deponent back to state that the college, namely so-and-so college, applied for a recognition before the Eastern Regional Council, NCTE, through online process on 36/2016 for additional teacher education and program, and with required fees of 1,50,000. After considering the application, ERC in its meeting held on so-and-so date, issue show cause notice for non-fulfillment of the condition under the regulation 2014 and provide an opportunity under section 14(3)(b) of the NCTE Act to submit reply within a period of 21 days. However, the college failed to submit any reply within the stipulated period. As such, recognition for B.Ed program was refused by the order dated so-and-so under section so-and-so of the Act. And extra 15, page 57 of the writ petition. Then, my lord, next paragraph. Sorry, lordship. That your humble deponent back to state that the college, namely Mehtab Jamal Sen, did not file any appeal under section 18 of the Act, which provides that the appeal must be filed within a period of 60 days. Perhaps there is some mistake, my lord, here. 60 days from the date of issue of the refusal of the order, you file the appeal, but it is filed beyond 60 days, my lord. First, I'm taking the language they used. Then, okay, my lord, this refusal, date of issue of the refusal order on 2/1/2018, my lord, the petitioner submitted an appeal on 8/3/2021 before the appellate authority, which is after left by almost 3 years. The appellate authority considered the appeal and hearing took place on 28/9/2020, and but the committee did not accept the appeal on the ground of delay in filing the appeal by the petitioner. Now, next paragraph 4, my lord. Your humble petitioner beg to state that initially the college so-and-so submitted their application which was considered by ERC, but college failed to reply to the show cause notice in time subsequently to find appeal which is not within the stipulated period is provided under section 18 of the NCTE Act. The deponent further begs to state that the institution failed to submit the required document which is necessary for granting of recognition of institution under regulation of 2014. Therefore, failure of the college authority to comply the show cause notice resulting in refusal of recognition by NCERC. The appeal preferred by the college authority after lapse of 60 days without any valid reason or explanation regarding the delay in filing the appeal before the appellate authority. Thus, there is no violation of any right or any illegality in passing the order refusal, as well as non-admitting of appeal by the appellate authority. Now, paragraph 5, that your humble petitioner beg to state that against the order dated so-and-so and appellate, the petitioner approves before this honorable court with a prayer for setting aside both the orders and also for a direction to reconcile the application which was rejected on 2/1/2021. So that is, my lord, the whatever the date of the writ petition, my lord, to apply relief sought for in the writ petition in a nutshell, my lord. Then paragraph says that your humble deponent beg to state the college may apply for fresh application for recognition, my lord. That is their, my lord, stand, whatever after their, so apply for this stand when the online portal for the fresh application opened by ERC with all necessary document under NCTE regulation 2014 on such application shall be made, on such applications same shall be considered on merit. So that is in a nutshell. They are standing in that writ petition, my lord. Now, lordship will kindly turn to the order passed by this honorable court, my lord. In this petition, my lord, 6612 of 2021, page 90, lordship. Now, the lordship will start that the petitioner is aggrieved by the impine order dated 4/10/2001 passed by the Deputy Secretary of the appeal under section 18(1) of 1993 by the petitioner on the ground of delay in preferring the appeal, which appeal was directed against the order dated to my lord. Now, lordship will find accordingly, my lord, the order was set as a 91, my lord. If your lordship look in the operative part, last part 1 paragraph. Accordingly, while setting aside the impine order dated 4/10/2001 passed by the Deputy Secretary under Section 18 of the NCTE Act, the appellate authority thereby directed to consider the appeal filed by the on its own merit and according to the law as expeditiously as possible, preferably within a period of 2 months from the date of receipt of the certified copy of this order, along with the copy of the writ petition, which shall be submitted by the petitioner so and so. So, my lord, the appellate order, which was dismissed on the sole ground of delay, was set aside. The matter was remanded to the my lord appellate authority to consider afresh, my lord. Now, my lord, in pursuance of that order, and fresh appellate order was passed by the appellate authority. That start from page, my lord, 92 and Annexure 21.
Yes.
Now, your lordship starts order 1 ground of appeal, my lord. The appeal Mahatab College 1 so and so dated preferred by the order against 2/1/2018 of the Eastern Regional Committee refusing recognition for conducting B.Ed course on certain grounds. The relevant aspect of the said refusal order of 2/1/2018 is being reproduced hereunder. Hereunder. Show cause notice was issued on 14/2/2017 on the following ground. My lord has already gone through the ground of rejection, my lord. That has been repeated here in this order, my lord. Now, lordship will to submission made by the appellant, my lord. C. Suraj Jamal, representative Suraj Jamal, representative of Mehatab Jamal, B.Ed College, so and so, appeared online to present his case on the appellant institution on 7/10/2022 and 8/10/2000 appeal memoranda. The appellant institution had made the following submission due to shortage of time. Same thing, my lord. Now will outcome of the appeal, my lord, the fresh consideration. The appeal committee perused the relevant record and the documents submitted by the appellant institution. The appeal committee noted that the application is refused by order dated so and so. The appeal committee further noted that petitioner institution filed a writ petition so and so before the Honorable Guwahati High Court against the impugn order dated 4/10/2021 passed by the appellate authority NCTE, whereby the refusal order dated 2000 by ERC was under challenge. The Honorable High Court by order dated 31/8/2020 disposed the instant petition with a following direction. On perusal of the impugn order dated so and so passed by it is noticed that the petitioner preferred appeal against the so and so regional. Thus, appeal filed the petitioners beyond though the my lord granted accordingly the order of the impugn order set aside, the appeal they different. Then lordship will find that is case kept my lord now in compliance. That is important, my lord. If a lordship page 94, my lord, last in compliance with the court's order dated 31/8/2022 passed by the Honorable Guwahati High Court in WPC number so and so, title so and so versus so and so. The appeal committee noted that the main grounds of refusal recognition was that the appellant failed to submit the reply to the show cause notice. The further committee noted that the institution in the appeal, although has submitted the following documents, my lord. Now, my lord, the main ground of the rejection of appeal, which also, my lord, taken into consideration after, my lord, the matter was remanded before the appellate authority, that, my lord, will find it there, my lord. Further, the appellate committee lordship will find it is noted that the main ground of refusal of recognition, so they have noted the ground, because these are the ground on which, my lord, the recognition was refused by NCTE ERC, my lord. Against that, we first we have approached the appellate authority. That appeal was dismissed solely on the ground of delay. We approached this honorable court. The honorable court set aside this order and instead decided on the merit. So while deciding the merit, the appellate authority also, my lord, gone into this, my lord. That what is the ground of rejection by the ERC, my lord? Failed to submit a reply to the show cause notice dated 14/2/2017, because in Ferguson, according to them, they said these are the shortcomings we have noticed, so you make good these shortcomings. Now, lordship will find. Further, the appellate committee noted that the appellant institution in the appeal, along with the memorandum appeal, has submitted the following document. So, my lord, we have submitted all the documents, my lord, you will say. No objection certificate from the government of Assam elementary education in respect to the 4-year integrated teacher education, BA, BEd, BSc, BEd. That I'll come, my lord, later, why it is, my lord, objection was granted to, my lord, conduct, my lord, integrated BEd course, my lord. Then my no objection certificate issued by the affiliating authority, Guwahati University, in respect of BEd course, letter dated so and so, granting permission affiliation by the Guwahati University, trust it dated so and so, photocopy of the list document and other related document. The committee noted that. Next, my lord, page 95. Application of the Institute of BEd program are refused by order dated. It has been observed the committee, since the institution has been granted the recognition, and in view of the decision taken by the central body NCTE meeting on 14/7/2022, inter alia considered the following agenda. So, my lord, the main ground of rejection against which you filed the appeal, my lord, before the appellate authority, my lord, which they also recognize by the appellate authority that yes, this is the ground on which your affiliation was application for affiliation was recognition was rejected, my lord. But now lordship will say on what ground they rejected my appeal this time. That, my lord, will find that next one, agenda number 5. The decision on application irrespective of any course which are on with a line on NEP 2022-20. My lord, NEP 2020 National Education and Policy, my lord. This National Educational Policy, my lord, when we applied for recognition, when they rejected, that is not at all a ground of rejection of our application. Because when we applied for recognition, when they have rejected us, this NEP has not even came to light, my lord. This not even came to light. And that is not a ground of rejection by any of the authority. by the, my lord, the Eastern Regional Council, my lord, the authority who is supposed to grant or refuse the recognition, my lord. Now, lordship will find NEP 2020 lays down that teacher education institution will be gradually moved into multidisciplinary college and the university by 2030. My lord, so it is not that, my lord, it will convert it into multidisciplinary college or the institution instantly. It was came in for 22, my lord. So 2030 only by phase wise, my lord. Because lordship is aware. Because, my lord, many institutions, college, B.Ed education, which are imparting 2 years B.Ed course, my lord, throughout the India even, my lord, they are still imparting the education. Therefore, as per the policy, they take it as, my lord, the outer limit of 2030. That gradually by 2030, we will, my lord, make it a multidisciplinary institution. That, in my humble understanding, that is all the concept of, my lord, this. Now, 2 are B.Ed course next will be offered only for those who have already obtained bachelor degree in other specialized subject, and 1-year program for those who have completed the equivalent 4-year disciplinary bachelor degree or have obtained a master degree in specialty or and wish to become a subject teacher in the specialty. So therefore, my lord, even they said 2 years B.Ed course is not at all bad, my lord. But it is for the specialized subject. Suppose if I conduct a specialized subject, my lord, then a degree in a specialized subject, I can go for a 2 years B.Ed, my lord. There is no bar. So far this clause is concerned, my lord. And my lord will say, as per provision of section 12 of NCTE Act, it will be a duty of the council to take all steps as it thinks fit for ensuring planned and coordinated development of the teachers and education. They are then, my lord, they have said there are approximately 430 applications for various teachers institution under NEP, the other than diploma level courses pending in the reference stage of RC. NEP 2022 has brought a paradigm shift in the teacher education sector. Accordingly, NCTE is also revamping its various curricula of ITP, 2 years B.Ed, 1 year B.Ed, and introducing new 4 years physical education and 4 years art education in line with the NAP 2022. These courses are also to be aligned to the various criteria laid down by UJC in alignment with so and so. So and so and so and so. However, existing courses which are currently running are not, those various aspect, IG credit system, 4 stages, so the school education, entry exit policy, no hard separation, etc. These change in the curricula would also necessitate changes in the norm, standard, and regulation. For the reason aforementioned, it is not feasible to process any pending application. Then, my lord, after decision, lordship will find. After perusal of that, page 96, my lord, they have discussed all this. After perusal of memorandum application, affidavit, document, record, and oral hearing, in the light of the decision taken by the 14/7/2022, that 14/7/2000 resolution, my lord, lordship will, I have just taken take a lordship to that, page 95. The committee, then a meeting was held by 55 meeting held on 14/7/22. So, my lord, my application this time was rejected on the basis of an, my lord, decision taken in a 55 meeting, my lord, which was not at all a ground, never a ground. Because the appeal, the lordship is aware, is a continuation of the original proceeding, my lord. In original proceeding, that was not at all there. I submitted my application, I submitted a memorandum of my appeal. So they have set down a ground which was not a ground of appeal. So at this stage, my lord, what I submit, my lord, subject to my lord's correction is that, my lord, let the matter, my lord, if I don't know what my learned friend will say, my lord, let the matter be maybe remanded, my lord. Since, my lord, let them also look into this ground, whatever the ground, originally they have rejected my recognition, my lord. And thereafter, my lord, they will decide the issue. Because, my lord, what I submit, my lord, that in that case, I may not lose a forum, my lord. Then I'll get an opportunity, my lord. Even this time also my appeal, I can approach your lordship, my lord. This is my humble submission at this stage, my lord. Let them consider it afresh on the ground on which My application was rejected by the RC. It is not at all a ground, my lord. And 2020, just a policy decision. It is just a policy decision, my lord. And application is made under the act. It's just a policy decision, my lord. And lordship's policy decision is not enforceable in the law. It's mere a guideline. And they say it is 2030, the time is there. So, my lord, to cut short, I am submitting, my lord. If this matter is only remanded to the appellate authority, let them decide on all the issues, including the issues on ground on which my rejection. There is no whispering on that. On the ground on which appeal was preferred. I did not prefer the appeal on the ground of NEP. They also did not rejected my application on the ground, recognition on the ground of NEP 2000, because NEP 2020 was not even born then. Man.
May I please, Your Lordship? Here in this case, my lord, the general body have decided the issue. General body decision is in terms of section 12 of the NCTE Act, my lord. The section 12, my lord, implied their implied power there is to the NCTE, my lord, to frame the guidelines and regulations, my lord. In this respect, my lord, functions of the council, my lord. That is section 12, my lord. In terms of section 12, my lord, we have framed a guideline that no new colleges will be granted recognition, my lord, till 2030, my lord. Since there are so many colleges of 2 years, my lord, that will be upgraded, my lord.
See, the issue is that the issue cost notice served on the petitioner, which the petitioners they are saying they did not get, were on certain parameters.
My lord.
And the rejection for the B.Ed degree of petitioner's college was on those grounds. Correct. But then the appellate authority, while considering the matter, appears to have taken the resolution of the ERC.
General body decision,
of the general body decision.
That is in terms of section 12 of the NCTE.
Yeah, that's fine. But then the appeal should have been considered in terms of the rejection, in terms of the show cause notice. Correct.
In that case, your lordship may remand, but your lordship may kindly put my submission, my lord, in this case, my lord. Since, my lord, there is a general decision from the NCTE, my lord, in this restaurant, we have filed our affidavit also, my lord. At para 3 and 4, we have already 3, 4, and 5, we have already clarified. And general body decision is also there at annexure A, my lord.
Annexure?
Annexure A, my lord, page 165, my lord. Agenda 5, my lord. Decision of application of irrespective of any codes which are not in line with the NEP 2020, page 167, my lord.
That already, my lord, there is there only, my lord. The order of rejection, that was there also, quoted in the order of rejection. Same thing.
And page 170, my lord, that is agenda 8, my lord. That is decision regarding opening of the portal for inviting fresh applications, because, my lord, this college is yet to be recognized by the NCTE and they have to apply for a fresh application, my lord. That is in page 170, my lord.
First, the appellate authority should decide that at fresh, my lord. Then the online application, that will come, my lord.
Agenda 8, my lord. So your, my lord, may I kindly record my submissions, my lord, in this respect, my lord. And para 3, 4, and 5, my lord, is our affidavit, my lord. That is at page 160, 161, and 163, my lord. And then your lordship may pass appropriate order.
And the appellate authority, my lord, they have also noted, if your lordship looking into page 94 again of the writ petition, my lord will find a no objection certificate dated 12/2/2021 issued by the government of Assam Elementary Education Department in respect of 4 years integrated teacher education, BA, B.Ed, and BSc, B.Ed. So, my lord, that was also, my lord, that is also multidisciplinary, 4 years integrated. So, you've already, my lord, they received the NOC. So, you can start, my lord, also that. There's no problem.
We have clarified our stand, my lord, in why you have taken this decision in our affidavit also, my lord. At para 3, 4, and 5, my lord. Why we have to take this decision, my lord? Your lordship may kindly peruse this. This decision is applicable in all over India, my lord, not only for this college. That is also taken also in terms of NCT. NCT Act, section 12 of the NCT Act.
Mr. PJ Ghosh.
Yes, please.
Learned counsel for the petition. Who appears for union?
ইউনিয়নের কি আছে দেখো না এখানে বসে আছে
Can we record any of
Yes,
this?
I have signed.
I will give to name. I will give.
I'll just record H. Gupta's name.
Yes, my lord, I will
H.
inform.
Gupta, Mr. H. Gupta, the CGC appears for the respond number 1. And Mr. J. Alam, I Alam, the standing counsel NCTE, appears for the respondents 2, 3, and 4. Stop. Para. The petitioner is aggrieved by the impugned order dated 19/10/2022 issued by the
Appellate authority.
Deputy Secretary within bracket
Yes.
appeal, comma, National Council for Teacher Education,
My lord.
within bracket. On the ground that the appeal filed by the petitioner was disposed of by considering the decision of the general body
Of the NCT in its 55th meeting. That is your lordship have founded page 55.
of the general body meeting of the NCT held on 14 July 2022, particularly with reference to agenda number 5 and agenda number
Only 5 is there.
with reference to agenda number 5. Stop. It is the case of the petition that the application filed by the petitioner seeking recognition for imparting B.Ed program was rejected by an order dated 2/1/2018 by an order dated 2/1/2018 on 10 different grounds.
Yes, ma'am. Yes, ma'am.
On 10 different grounds. Stop. However, the appellate authority disposed of the appeal filed by the petitioner without taking into consideration the reasons why the application of the petitioner was rejected on the said 10 different grounds. Stop.
Rejected by only on the ground of delay, my lord. There is a statutory provision
No,
of
no.
50 days, my lord.
That is a different thing. That is, I'll come to it. The petitioner filed an application seeking recognition for imparting B.Ed program through the institution named Metab Jamal B.Ed College,
Yes, ma'am.
village Ponpahar,
Yes, my lord.
district Parpita, in terms of the NCTE Act 1993. Stop. However, the said application was rejected by an order dated 2/1/2018 issued by the regional director on the grounds that the the show cause notice issued to the petitioner on 14/2/2017 on 10 different grounds was not replied by the institution.
Page 69 also bottom here, they have also written it. The reply from the institution has not been received within the stipulated.
No, has not replied. No, has not been, what did they say? That within the stipulated period. Stop. Accordingly, the committee refused recognition of applied B.Ed program under section 14(3) within bracket B of the NCTE 1993. Stop. Against the said rejection order dated 2/1/2018, the petitioner filed an appeal under section 18 of the NCTE Act 1993 on 8/3/2021. Stop. The said appeal filed by the petitioner was rejected by the order dated 4/10/2021 on the ground that there was delay in filing the appeal. Stop. Being aggrieved with the order dated 4/10/2021, the petitioner filed a writ petition before this court, which was registered as WBC number 6612 of 2021, which was disposed of by order dated 31/8/2022. With the following directions. Page 90. 8A. Stop. Para. Consequent thereto, comma, the petitioner again filed an appeal under section 18 of the NCTE Act. When did you file your appeal?
My lord, we did not that appeal. My appeal was filed original, my lord. That appeal was the file,
Okay, okay.
original file, that was there.
Sorry, yeah. Consequent that, the appellate authority in the NCTE
Yes, ma'am.
took up the appeal filed by the petitioner and heard the matter on 7/10/2022 and 8/10/2022. Stop. Thereafter, an order dated 19/10/2022 was passed by the Deputy Secretary with appeal, NCTE, and whereby the appeal filed by the petitioner was again rejected. Stop. Para. Being aggrieved, the petitioner is again before this court by way of the present petition. Stop. Para. The authorities in the NCTE has filed counter affidavit and is represented by Mr. Ayala, Learned Standing Counsel, NCTE. Stop. It is the submission of the Learned Standing Counsel, NCTE, that the general body meeting of NCTE was held on, that the general body meeting of the NCTE held its 55th, no, don't say like that. It is submission of the Learned Standing Counsel for the NCTE that in the meeting, in the 55th general body meeting of NCTE held on 14 July 2022, the resolution was passed against agenda number 5. That the NEP 2020 that the general body meeting adopted the resolution against agenda number 5 and the same reads as under. Stop. It will be page 168, isn't it?
My lord, 167, my lord.
No, 167 is that consideration, but the decision is 168.
My lord.
In light of the above, council members unanimously decided the following.
My lord, my lord.
Correct.
My lord.
B to B, page 168. Stop. Therefore, comma, when the appellate authority considered the appeal filed by the petition,
My lord, agenda number 8 also included, your lord. At page 170, my lord. That is portal for fresh inviting fresh applications.
then they say further, the general body meeting
In the light of the above, council member honorable cited the following. This is
with
stated
regard to agenda number 8, also resolved as under C to C. Page 17. Stop. Para. sufferer. Accordingly, the appellate authority, while considering the appeal filed by the petitioner, disposed of the same by taking into consideration the resolution passed by the 55th General Body Meeting with regard to agenda number 5. Stop. Therefore, there's nothing wrong in the order dated 19/10/2022, by which the appeal filed by the petitioner was rejected. Stop. Para. On a perusal of the impugned order dated 19/10/2022, passed by the appellate authority, it is noticed that the appellate authority considered only the resolution taken by the 55th General Body Meeting with regard to agenda number 5, and thereafter rejected the case of the petition. Stop. However, what is to be noted is that the appeal filed by the petitioner was against the order dated 2/1/2018, by which the application made by the petitioner for for grant of recognition for conduct of B.Ed program online was rejected on the basis of the show cause notice issued on 14/2/2017 on 10 different grounds. Stop. Admittedly, the appellate authorities did not consider the grounds taken by the petitioner in the appeal filed by them. Stop. Therefore, without expressing any opinion on the merit of the case, the matter is remanded back to the appellate authority.
Respondent number 3, ma'am.
Oblique. Respondent number 3.
Deputy Secretary appeal, page 5, ma'am.
To reconsider the case of the petition, to reconsider the appeal filed by the petition, by taking into consideration the reasons for which the application of the petitioner was rejected by the order dated 2/1/2000. Stop. Let such appeal be considered and disposed of within a period of
4 weeks
4 weeks from the date of receipt
of the certificate
of the from the date of receipt of a certified copy of the order of this court. Stop. While disposing of the appeal, the petitioner, the appellate authority shall also give an opportunity of hearing to the petitioner. Stop. With the aforesaid directions.
Malo, this, my humble summary, this order part of required to be set aside.
Yes, yes,
2010, 2020.
Accordingly, the order dated 10. Nineteen ten. Passed by the Deputy Secretary within bracket appeal. NCT is set aside with motion.
Obliged,
The
sir.
official observations in that issue disposed.
Obliged.
20 to 23 admission.
May I please, your lord. My lord, both learned senior councils are in lakes in court number 27, my lord. Yes, my lord, there is an, I have in the record, my lord, there is an interim order, my lord, on dated 20/03/2023. It says 20/03/2023, my lord. This is the first order, my lord. 20/03/2023. First order. First order, my lord. It has observed that, my lord, the impugn advertisement so and so dated 21/2/2023 issued by the so and so Assam Engineering Service Recruitment Board shall be subject to the outcome of this petition.
That is
It
the
will
only.
be same, my lord, yeah.
So there's no need to start
Yes.
any. Okay, heard, Mr.
S. Hazarika.
S. Hazarika, and the council for the petition. Psyche is not.
He is also in lakes. Councils are in lakes.
Then I'll, on his request, on your request,
Both the parties for vacation.
okay, as well as Mr. S. Das, Learned Standing Council, Higher Education Department, and MS P. Sharma, Learned Council, for the response number 5. Stop. On request made by the parties, please conduct it after the observation.
One thing, my lord, I would like to point out, my lord. It's not that my department cannot, my lord, regularize the 3F appointees, my lord. So recently, one advertisement has been issued, my lord, where my lord 3F appointees has been regularized, my lord.
That will consider.
Yes, my lord. Obliged.